Hi, guys. What is going on? If you saw my post, we are still waiting on Adrian Love to file the response for the state. Let me know if that surprises you or if you're not surprised. Drop your answer in the chat. But we have 3 new filings from Brian Steele, and we do have a quick update from Doug Weinstein on behalf of Yak Gotti. So we've got 2 documents we're going to look at while we wait. We'll keep refreshing. Jozsef Papp is bringing us the 3 filings from Brian Steele. So one of them is just an updated witness list. And he went and circled it. So you can see that we've got Judge Glanville, we've got Simone Hilton, and we've got Adrian Love now officially on Brian Steele's updated witness list. So that's one filing today. And then we've also got we've got a motion from Brian Steele for a fair trial and a mistrial, where he really, really goes at Adrian Love. It's 13 pages. We're going to look at that. And then we've also got a motion for, Brian Steele wants the judge to make the correct ruling on improper objections by the state. So that's kind of been a fight that's been a little bit back and forth. We're going to look at that at 6 pages. And then the small update from Doug Weinstein, shout out to Jozsef Papp again, is just that he has withdrawn without prejudice, which means he could refile. He's withdrawn the emergency petition for a writ of mandamus, but it's without prejudice, so he could file it again as need be. So those are the small updates. Let's start with one of Brian Steele's infamously giant and long titles. What is that? 5 lines? We're on a 5th line there. Nothing new from Brian Steele with that, except for yesterday when he used footnotes instead of length. But we'll get right into it. He's looking for a motion for a fair trial, as well as a motion for a list of dates and persons who participated in any ex parte communications with the court and the topic of same. So what were those meetings and communications about? And also a motion for a mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. Now, we talked about this while we were going through that supplement. He put a footnote that said, look, everything we're talking about here, we also want to ask for the recusal of lawyer Simone Hilton and lawyer Adrian Love. And you could kind of tell in that supplement yesterday, he was setting the stage to start pushing for prosecutorial misconduct and a mistrial for that reason, which, because of double jeopardy coming into play, it would bar a retrial. So comes now Mr. Jeffrey Williams, by and through undersigned counsel, hereby files this motion for a fair trial and a motion for any other ex parte communication you haven't told us about, and a motion for a mistrial based on the judicial and prosecutorial misconduct. Mr. Williams is innocent of all crimes in the above referenced indictment. From the inception, this trial has been constitutionally unfair, as this court has failed to be impartial to Mr. Williams and or his counsel. So, we've seen a lot of that. We've talked about that a lot too. Some of the statements that Judge Glanville has made, such as calling Brian Steele unprepared in front of his client in the middle of open court. Not a good look. And the court has been objectively biased in favor of the prosecution. Some examples of same include, but are not limited to, the below. And we're going to read the footnote before these examples. So in this footnote, he says, during voir dire, lawyer Love misrepresented the demeanor of venere jurors to attempt to have the court excuse, for cause, potential jurors that lawyer Love did not want to serve on the qualified venere panel. The court did not admonish lawyer Love for these misrepresentations. Undersigned counsel does not have a transcript of voir dire and cannot locate YouTube video or audio of the trial's voir dire on these points. So, interesting that we saw Brian Steele file a bunch of transcripts into the record and add it to his appeal volume this week. So, to me, I would guess that Brian Steele maybe tried to get a transcript of this. It would be weird if he's writing this motion, is making a point of it, and didn't just go ask for a copy of the transcript first. So I'm wondering if there's something missing. Maybe they didn't record voir dire. Maybe that's how they do it typically in Fulton County in Georgia. I don't know. That's kind of interesting there. But in any case here, again, going back to this idea that Brian Steele is setting the stage not just to ask for a mistrial now, but use these same arguments that would warrant a mistrial now. These are going to be the same arguments you're going to see come up if it goes to an appeal. And issues with jury selection, if there's an issue with jury selection and the judge has an opportunity to correct it but does not, that can be a very strong appeal issue if you can prove it, if you can demonstrate that there wasn't a justifiable reason for someone to strike this juror. So this is why this footnote's going to be important, but I'm really curious why we don't have a transcript. So these examples that we're going to get to that are supposed to show how this court has been unfair. First is prior to opening statements. This court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, 2023. Shout out to November 2023. So that objections could be made prior to presentation of the opening statement. Did you guys watch opening statements? Because you saw this. Let me know if you saw this objection in opening statements. On Friday, November 24th, 2023, at 4:58 p.m., Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, Lawyer Love, spoiler alert if you never watched the beginning, Lawyer Love showed a completely different, never-before-seen demonstrative aid, which was in clear violation of the court's order, and the defense objected right away. The court denied Mr. Williams' timely motion for a mistrial, right then and there during opening statements, and there were no consequences meted out by the court for Lawyer Love's intentional misconduct. During the same opening statement, Lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in the case. Specifically, during her PowerPoint presentation, Lawyer Love highlighted to the jury that undersigned counsel represented Coenziety Blaylock. Now, we heard about that too. If you watched it on YouTube, you saw this. Again, there were no consequences meted out by the court. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Mr. Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11th, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence, as Mr. Bean never went to Grady Hospital on September 11th, 2013. And then we have all the timestamps of these sidebars. And if we don't get a filing, did we get a response? I see you guys in the chat a little bit. All right, it's 81 pages. Oh my gosh. Do you guys want to switch over? Put a 1 in the chat if you want to go to the state's response. Put a 2 if you want to finish Steele's. You guys can call the choices here. And shout out to Drea. Everyone show Drea some love in the chat. All right, we're going to just go over to this document. All right, so we got a little bit of spice towards Adrian Love to set the stage for Adrian Love's response. We've got some interesting font choices here. Let's do it, you guys. And you can see at the top, you can see at the top, 5:42 p.m. The state's response to defendant's motions to recuse Chief Judge Earl Glanville in the trial of the above-styled case. And give me 1 second. I'm going to change the title on YouTube so people don't come in and get confused. While I share your thoughts on the brief bit of Brian Steele's motion that we read so far. And let's see. State responds. All right. So that's saved. All right. So midway through this now months-long trial, defendant Jeffrey Williams and defendant Diamante Kendrick have each filed a motion to recuse Chief Judge Earl Glanville. Hereinafter, they're just going to call that cumulatively the motions. And defendant has filed a supplement to the motions, hereinafter supplement. Now I've got a question already. Are we going to ignore the Bumpus motion? Because remember, Rachel Krause was like, she said she wanted a response to all 3. and then put a footnote that it was only the state asserting that it was moot. So let's see if we get a mention of the 3 motions. The state recognizes that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court. So Love is still calling it the honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the 3 requisite determinations. 1, whether the motion was timely filed. 2, whether any affidavit made in support of the motion is legally sufficient. And 3, whether, if some or all of the facts set forth in the affidavit are true, recusal is authorized. And they're citing Henderson v. State here, that once a motion to recuse is filed with the trial judge whose recusal sought, so Glanville, that judge must make these 3 threshold determinations. Accordingly, it falls to this honorable court. Should we do an honorable counter? It falls to this honorable court to make those determinations. And then we're also going to get Burt v. State cited here, which is the one that says, if the court doesn't make these 3 determinations at the time that the motion's reassigned, if he can't make such determinations after, then the assigned judge would have to make these determinations, which the alleged recusant judge was supposed to have made. So they're going to argue that this backs them up. So because this judge, Glanville, couldn't make it themselves, the judge that's now assigned to this case should make those same determinations that Judge Glanville already made. I can't wait to see a response to this. So as set forth below, though defendant's motion and supplement are in part timely, and the affidavits in support of defendant's motion and supplement are in part legally sufficient, underlined, none of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. What? And we underline that? Guys, nothing. Even if assumed to be true. Do you realize what they're arguing here on page 2? Even if we assume that everything in these motions and affidavits was true, Love is arguing that none of it would warrant recusal of Judge Glanville. Absolutely not. Absolutely not. How is this even being argued here? Let me make it bigger in case you guys can't see what I'm seeing. I read it right? Even none of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. Therefore, the motions and supplements should therefore just be denied. So we're just arguing whatever we want to argue. I guess that's what we're going to get 81 pages. Hold on, is this 81 pages without? Okay, it's not that long, guys. We've got exhibits. Because I don't know if I can make it through 81 pages of that. It looks like 9. So, holy moly. I don't even like to be this animated this soon in a reading. Let's get the factual background according to Adrian Love. The calling of state's witness Kenneth Copeland on June 7th. On June 6, 2024, in response to an inquiry from counsel for the defendants in this case, they're talking about Brian Steele's inquiry, the state announced that this is June 7th. The state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th, 2024. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland, and that Mr. Copeland would be asserting his Fifth Amendment privilege if called to testify on June 7th. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, what are we going to get here, guys? Who are represented respectively by Brian Steele and Max Shart. Melnick copied Brian Steele and Max Shart on his communication with the state regarding Mr. Copeland's intention not to testify. So we've got 2 footnotes here. We have 2 footnotes. So first we're going to get the Melnick emails. We're also going to get a motion to compel the testimony of witness Kenneth Copeland and an order compelling testimony. So let's bookmark those. We'll get through the exhibits after we get through the argument here. This is going to be interesting because this is how they're going to argue that Melnick just suddenly injected himself. And they're going to continue. I bet you they're going to continue to argue that Copeland never mentioned he had an attorney or mentioned Melnick's name or anything of the such. So In preparation for Trial Deputy District Attorney Hilton, and they're giving her the full title, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the fifth or say that he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7th, 2024. But remember, according to the transcripts for Monday, don't forget that by the time we get to June 10th, that transcript tells us that Hilton and Copeland were speaking alone in the hallway while Kayla was waiting for Copeland to get into the Star Chamber. The Star Chamber. So let's pay attention to how they paint the timeline here. Maybe we have it wrong. But they're saying here we stopped talking to Copeland on June 7th. Let's see if they omit the morning of June 10th. Pursuant to OCGA 245507, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court. The court issued an order granting the state's motion. On June 7th, 2024, after court was called to order, Mr. Melnick appeared before the court and informed the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination in the presence of each defendant currently on trial and each of their respective attorneys. Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order of the court pursuant to OCGA 245507, directing Mr. Copeland to testify and extending immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland, in the presence of every defendant currently on trial and each of their respective attorneys, that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying. Mr. Copeland thereafter stated his... Can you imagine if she was reading this out loud? So Mr. Steele also has some long sentences, but every single one of these is very long. Mr. Copeland thereafter stated his intention to testify, and Mr. Melnick looked towards Mr. Steele and Mr. Shart and shrugged his shoulders. This is that signaling that she thinks is so nefarious. So let's look at it, guys. Let's pull it. We're not gonna play this. We'll play this later. But is she trying to footnote? Do you guys understand the point I'm about to make here? She's time-stamping 16 minutes. But this footnote is attached to what would have been 1 instant. And she's time-stamping 16 minutes worth of footage. As a footnote, they shrug their shoulders at each other. After motions hearings, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After lunch, the jury was called in, and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions, and when asked his age and years, Mr. Copeland responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody. In open court, in the presence of all the defendants currently on trial, and in the presence of each defendant's respective attorneys, Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Copeland back to court on Monday, June 10th, 2024, to allow Mr. Melnick, Mr. Copeland, to purge himself of his contempt by testifying. So they're going to try to argue that the defense was disclosed. Everything that they needed to know was disclosed to them. Mr. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint stand-in counsel Kayla Bumpus to represent Mr. Copeland in court the following Monday. The June 10th, 2024 meeting regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Judge Glanville. Now, again, what I'm personally looking for is how they present that time period where Copeland was speaking with Hilton outside, like in the hallway somewhere else, while everybody else was waiting in chambers. The beginning, like first third of that transcript. Let's see if they properly convey that. And then, hey, I'm just catching this randomly, but haven't seen you in a while, Frodo, so good to see you. On Monday morning, prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Kenneth Copeland. Kenneth Copeland, did we repeat that twice? So, Kenneth Copeland, the court, and an attorney for the state to discuss the contempt proceeding initiated against Mr. Copeland upon the state's motion. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting were Chief Deputy District Attorney Love, Attorney Kayla Bumpus, investigators for the state, and the Honorable Chief Judge Glanville, and later Kenneth Copeland, and we are getting that they joined later, Kenneth Copeland and Deputy District Attorney Hilton. What's this footnote? So the footnote's just the transcript. Matters addressed during the meeting concerned only the contempt proceedings. Okay, cool. So the next line, we are not having it stated here, even though they do cite to the transcript. They're not stating here that Hilton and Copeland were speaking with each other. They just say that they joined later. Matters addressed during this meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included topics Mr. Copeland's rights and representation as it relates to the proceeding, Mr. Copeland's obligations under OCGA 245507, and answers to questions posed by Mr. Copeland regarding matters related to the same, such as the distinction between purging oneself of contempt as addressed by OCGA 245507 and perjury as prohibited by OCGA 245507. So they're referencing a moment where he didn't understand something. Are they going to mention that they were kind of giving him legal advice on how to avoid perjury by saying, I don't recall, rather than pleading the fifth? You think they'll do that? With the exception of the times where Mr. Copeland was afforded an opportunity to speak with Ms. Bumpus alone, and in bold, guys, the entire meeting was taken down by the court reporter. And was that a different footnote? Okay, so we're gonna... Got a footnote there. We've got a lot of exhibits. And now we're going after Brian Steele. Shout out to Ollie the Macaw for becoming a new member. Guys, there's a parrot emoji. It's called a parrot. It's not a macaw, but it's the best we've got. So if you want to drop a makeshift macaw emoji in the chat, shout out to Ollie. Brian Steele's defiance of the court's commands and subsequent contempt ruling. Do you guys think the prosecution's playing team up with the judge here? Because I wonder if this is really something that the state needs to be involved in the argument for. You know what I mean? I don't know if that makes sense, but... And the Honorable Kayla Bumpus is in the chat. If you want to come up, let me drop a link. And I will be like reading through it, but we can chop it up after and at key points. That link is only for Kayla for now. Maybe other people can come up later. But let's see, guys, because I get the feeling we're about to read something that really should be Judge Glanville's argument to make, but let's see what the state argues. Brian Steele's defiance of the court's commands and subsequent contempt ruling. After the meeting regarding Mr. Copeland's contempt and obligations under OCGA 245507, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal the Mr. Steele's source of information regarding in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. Well, do they mean the motion and the supplement that was just filed yesterday? Why is she connecting these like they were back-to-back in time? But Steele files a lot of motions, so maybe there was a motion and a supplement on June 10th also. I remember he filed for, the supersedeas bond. And am I tripping, or is she saying that after he disobeyed the court, as if it's all happening in a matter of moments, Brian Steele files the motion and supplement? Like, as if that wasn't yesterday, that supplement. You good, Kayla? You want to come up? Let me get some headphones in. And then make sure you give this channel an introduction. I know most people have, they know you have a channel. I love your name, the Honorable Kayla Bumpus. Everyone that doesn't know you on YouTube yet, an introduction.
No, finish first.
Okay, we're gonna finish. We're gonna finish. We're gonna see. We're gonna hear the state stand up for Judge Glanville a little bit more. So, argument and citation of authority. No fact set forth in defendant's motion or supplement authorizes the recusal of Chief Judge Glanville. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from, with all the italics bold and underlined, an extrajudicial source and result in an opinion on the merits of some basis other than what the judge learned from his participation in the case. Now, this is actually where we're going to get a problem about them mentioning this video, and maybe me and Kayla will talk about that a little bit more after this. There is a presumption that a trial judge, acting as a public official, faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exception of the defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared, defendant's motions and the supplement are based entirely, and we got caps now, all caps, on the defendant's assertions regarding the June 10th, 2024 meeting regarding the contempt proceedings against Kenneth Copeland, and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated requests to provide the court with information. Even though we had to wait 2 weeks for the court to provide transcripts of the ex parte. This is the grievance here by the state. The Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to the law. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify. Since no defendant in this case had a right to be present at the June 10th, 2024 in-chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland, the fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted this 10th day of July, 2024, Adrian Love, Chief Deputy District Attorney, the Fulton County District Attorney's Office. So we've got some exhibits, but Kayla, what's going on, Kayla?
Well, I don't know. I might have got on a little bit late, but I was wondering, like, is she late? I know I'm on Central Time, but what's going on? That
Oh, it
was
was filed at 5:42 is the timestamp here.
wasn't it due at 5?
Yep.
Oh,
And the
okay.
funny part is Steele filed 3 different filings and Weinstein filed. It was just withdrawing his thing, but it's kind of like, and not for nothing, but one of Steele's new filings is asking, it's very hilarious because this last paragraph that's all bolded and crazy is like, oh, there's only one. It's based entirely on one assertion about this one ex parte communication. But what did Steele ask for today? We want you to produce any other times that you met, any other dates that you met with anyone else, any other ex parte communications, and the subject matter thereof. So right as
Yeah,
she's saying this, Steele's like, whoop.
I got all those. Like, they come through my phone because once you file something on a case, you get every single filing. So I get all this stuff as it comes in.
Little steel bullets, like boop, boop, boop.
And this too, I got this too, but I didn't see she hasn't responded to the motion about me, has she?
No, and that's weird because, I mean, you saw how Rachel Kraus worded that, right? She
Mm-hmm.
asked for the response on all three. That's my understanding. And she made a footnote mentioning that it was the state asserting it was moot. But she didn't adopt that assertion.
Right. But anyway, back to that. Okay, so she says that I do believe that maybe the state wouldn't. I mean, the defense would not have had a right to be there if two things had happened. One, if the judge wasn't there. So if the defense didn't have a right to be there, then nor did the court. It would have been different if it was just me, the state, and Mr. Copeland. A big difference. Number one, and number two, I also think it would have been different if once certain facts developed, there became Brady issues, and all they had to do to correct that was notify the defense immediately. As soon as we came downstairs, it should have been, "Hey, this is what happened," and that would have cured everything, in my opinion.
And that's missing from this. Brady and Giglio have been mentioned numerous times, not just by Brian Steele, but Doug Weinstein had that in his motions as well. And they don't respond to that argument in this thing. So they're giving Rachel Kraus, who seems to me, based off her reading, we only got 4 pages on her one order and 2 or 3 on the other. Based on that limited reading, she looks like she's looking at the exact letter of the argument someone tries to make. And there's no counter argument to the issue of there being Brady Giglio information that wasn't evidence that wasn't handed over and disclosed to the defense. So they don't respond. What position does that leave a judge that wants to look at both arguments before making a decision? They've only got one side. So
I
they
think
missed that here.
I think Adrian thinks that has been solved, or not just Adrian, but whoever thinks that has been solved because the transcript's been released.
But that's not how things work. So, and
I
it's
just
only
think
her
that that's
signature, right?
I think that's the scapegoat that they're gonna say, like, hey, well, we gave them the transcript, so that's not relevant anymore. Honestly, I think that's what they're gonna say.
But what else is the problem? So if they're trying to say that Judge Glanville didn't violate, judicial conduct, he didn't violate any of those rules. He didn't come across something that wasn't part of the record. He didn't try to learn something that wasn't part of the record because we have this transcript. The court reporter transcribed it except for attorney-client privilege conversations. But then he mentions that video in court, and he tries to say on the record, "I didn't inquire about it. I didn't try to ask for it."
That it was just
Well,
given to him.
and he had to say that because he can't let it be known that he was seeking something that's not part of the record.
Record.
And that's really problematic. And I'm really waiting because Adrian Love dug her foot down in on this. Did you see the part where she called out Melnick signaling?
Yes, and it was 16 minutes almost.
Yeah, like link
A-
to the 1 minute clip of that happening then instead of 16 minutes.
And I want to say,
But
I want to do Judge Glanville like he did Attorney Steele. Who told you that? Who gave you that? Like, who just came and gave you that? The video. Like, so somebody just said, "Hey, look at this." I just don't. How does that work?
I don't know, would that maybe have been the security issue in the well, no, you said the meeting was after the ex parte, right? Where you
Yeah,
think
it
you
was
were in the
hours
hallway.
after. Yeah, that was hours after. So I'm just want to know why someone would just give that to him, or who would know, and who would know what time? Who would know? Maybe,
And I
maybe it
do
was
want to
the
see these
state.
Melnick emails. Do you
Oh
think
yeah,
she's
me
going
too.
to attach the FU one?
Yeah, that's what I was wondering because I'm pretty sure the emails are in there.
And I do want to say thank you. Shout out to Victor Mann, 7777, or maybe it's 7777. The state avoided responding to many of the matters accused of in the Star Chamber. And I agree. I mean, the more I get to marinate on it, you're going to hear me just pop out with, like, wait a minute. But, how do we avoid Brady and Giglio? And that's going to be a centerpiece. If someone's asking for a mistrial, if someone plans to go up on appeal, arguing that there was a failure to disclose Brady evidence, a failure to disclose Giglio evidence, that's something you should want to get in front of or at least respond to here. And they're just like, look the other way. So I agree. Like a lot of things are missing from this. And what do you think? So wait, we don't have the CC'd here. So this email right in the header, June 7th, it's not CC'd. It's from Jonathan Melnick to Hilton and to Love. Maybe they just didn't copy in the CCs here. But it's Friday at 11:56 a.m. My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. Truth. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go fuck yourself. And if you think I'm doing anything besides protecting my client, shout out to John Melnick. Of course, Love attached this. And then this is what he's responding to. So this is
The
from Adrian
African
Love.
proverb is wild, Cat.
Is that always in her signature?
That's all I see.
Okay, well, let me it's a little bit bigger. So this Melnick was responding to this at 11:53 from Adrian Love. Is your concern for your client or for Mr. Steele and Mr. Schartz? So did she remove them as CC'd recipients? That's
Yes.
hilarious. So, and then she had, this might be part of her signature, but if you want to go fast, go alone. If you want to go far, go together. Team Rico. like, and let's see, we've got at 11:52 a.m. So just a minute before, Melnick before that said, here is communication between myself and Miss Love, which pertains directly to the YSL case. And he's forwarding a message from Adrian Love to Melnick and also to Sheila Rosser, who's with the Fulton County District Attorney's Office. Good morning, Miss Rosser. The state asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. And then, okay, so we're going all the way back to March with this one. So from Jonathan Melnick, March 2nd, 2023, 4:42 p.m. to Adrian Love, Abigail Potter, and Sheila Rosser, and Adam Abate is CC'd. Here are both proposed bond orders. So this is a bond order. This is a bond order for March 2nd, back in 2023. So maybe this is here just to say that this is the last time they heard from Melnick. And they're saying that it was received. And then Miss Rosser, please find attached and proposed bond order agreed to by the state and Mr. Melnick. I'm attaching in Word format so that the court can revise where necessary. The two orders have only one distinction. One contains the curfew provision, and the court originally ordered, and the other does not. The state does not object to either, and Mr. Melnick asks that the curfew provision be removed. I have explained to Mr. Melnick that since the court originally ordered the curfew, the court must decide whether or not to keep it. Other than the curfew, Mr. Melnick finds the proposed order acceptable. Please let us know the court's decision. As part of the order contains a requirement of the defendant's signature acknowledging his understanding of all provisions and restrictions of the bond, and Mr. Melnick will visit Mr. Copeland to obtain his signature this week. Have a wonderful evening, Adrian Love. And Kayla, if I lost you, do you need another link? Just text me if you need the link, Kayla. And let's see. Oh, you're back. You have the link. Welcome back.
Sorry, guys. My phone never stops ringing.
Well, that's good usually, most of the time. And then now I think, I don't know if you saw it, but it jumped from like June 7th. And then he forwarded an attachment from, or a message from March 3rd. I think we lost you again. So I'm wondering, I don't know if these are all that, okay, Exhibit B, we're done with the emails. The ex parte motion for order to compel testimony necessary to public interest. Now, this is the deal, you guys. So this is the immunity. And this is what Melnick was just saying was no bueno, was no good. Pursuant to OCGA 245507, the state of Georgia, by and through Fonnie T. Willis, District Attorney of the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adrian Love, hereby moves this honorable court to compel a material witness, Kenneth Copeland, to provide testimony in the trial of the above-styled case. Further, in the event that said witness refuses to testify after being ordered to do so by this honorable court, the state moves this honorable court to hold said witness in contempt of court, pursuant to OCGA 245-507B, and have said witness committed to the Fulton County Jail until such time as the witnesses, well, maybe that's just a typo, until the witness purges himself of contempt by testifying as ordered by this honorable court. In support of this motion, the state shows this honorable court the following: that on January 10th, 2015, Donovan Thomas Jr. was gunned down and murdered at 330 McDaniel Street in Atlanta, Georgia. Reginald Hendricks and 14-year-old Cordelia Sanders were also struck by bullets during the shooting. The Fulton County Medical Examiner's Office determined that Thomas Jr.'s cause of death was gunshot wounds to the torso and determined that his manner of death was homicide. So this is probably where they're going to bring up the public interest part, why it is justifiable under public interest. Firearms evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down at 330 McDaniel Street in Atlanta revealed that a .7.62 rifle and at least one handgun were used in the murder of Thomas Jr. and the shooting of Hendricks and Sanders. Surveillance footage recovered from businesses in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Sanders were assailed by gunfire that originate from the sunroof and possibly window of a passing vehicle as the vehicle traveled west on McDaniel Street around 7:22 p.m. on Sunday, January 10th, 2015. This is how they should have opened with opening statements. This is a way better timeline of why we're here than what we got during opening statements. And then I also noticed, so Victor Mann says that email chain implicates the state. It shows they knew Melnick was Woody's counsel and knew his communication information, still the same email address, no excuse. And if I'm not mistaken, I think they had it wrong. They tried to argue that they hadn't heard from him since a different date. So there's inaccuracies there too. And then I think we've read this before. Have you guys seen this? Or do you want to go through it in full? Because this is really what they're citing as the reason. But the background is pretty much background on the case, why we're here, really centered on the Donovan Thomas, and why we need Woody's testimony for the sake of public interest. Because here, provided by 245-507, whenever in the judgment of the Attorney General or any district attorney, the testimony of any person or the production of evidence of any kind by any person in any criminal proceeding before a court or grand jury is necessary to the public interest, the Attorney General or the district attorney may request in writing the Superior Court to order such person to testify or produce evidence. So upon the order of the court, if this is granted, such person shall not be excused on the basis of the privilege against self-incrimination. So that's where that confusion over something's a right versus that right no longer being in play. You don't have that privilege anymore if you're given immunity. Such persons shall not be excused on the basis of privilege against self-incrimination from testifying or producing any evidence required, but no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he or she testified or produced evidence under court order. Now, we talked about this a lot when we read through the transcript. This just means that Woody's testimony should not be used as a lead to pursue an investigation, to pursue a reason to find, work backwards and kind of look for the crime and follow some breadcrumbs until you can unearth enough to go and charge Woody with something. But the flip side of that would be, do you trust this district attorney's office to not use Woody's testimony as a lead and then work backwards and then just say, well, we didn't use his testimony as a lead. We found this on our own. We looked over here. We saw this thing. That's how we found out. It's saying you can't use his testimony as a lead. He's protected from them using him as a lead. And that's only if you trust that they wouldn't do that. So However, such a person may nevertheless be prosecuted or subjected to penalty of or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of the state, the United States, or any other state. Any order entered under this code section shall be entered of record in the minutes of the court so as to afford a permanent record thereof, and any testimony given by a person pursuant to such order shall be transcribed and filed for permanent record in the office of the clerk of court. And now here we have, and of course it's underlined, if a person refuses to, and is this underlined in the original statute? Because she doesn't, okay, emphasis added is down here. I still think she should have had that at the end of this paragraph too, emphasis added for all of this stuff. Otherwise, it could be assumed that the emphasis is in the original writing of the code itself, as if the code is really strict in emphasizing this part. But B, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such person may be adjudged in contempt and committed to the county jail until such time as such a person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. If the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. So they cite all of that. And then, yeah. Who trusts them to do what's right? I totally agree. Kenneth Copeland has been subpoenaed to testify in the above styled case. Copeland is the next witness scheduled to testify in this case. Oh, so this is part of the order still. Dang, how long was this order? I don't remember it being this long when I read it. But there, let's see. And then Fonnie Willis signed off on it. And this was the contempt order. Oh, they're saying he must appear. Glanville signed that one. He granted the order. And then we have the transcript. So that's why this is so long. And then Exhibit D was just the signature from July 1st from Christina Weaver saying that this is a true and accurate, I further certify this transcript. So we've got that. That really wasn't that long. There was only 9 pages of core arguments. And then really some of the new information was just that correspondence between, Melnick, the emails. And what's interesting about that to me, I'm sure there's a few interesting reasons, but we have Adrian Love remove Max Shart and Brian Steele from the email communications. And that could be okay, but in the beginning of the transcript, she represented that quite a bit differently. Let's go to that page. Let's find page 1 of this transcript. Because maybe I'm remembering the transcript wrong. So let's reread this because she attached the transcript. Let's look at all this email convo. So the court reporter's ready, you guys. You guys in the chat, you be the eyes. How much does Miss Love's argument about this email exchange with Mr. Melnick line up with how she talked about it in the ex parte meeting? So Miss Love says, thank you. The concern that we wanted to bring to the court's attention is the state was twofold. One, we wanted to have the opportunity to impress upon Mr. Copeland, with representation present, that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second concern that I have is, and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday, I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 245507. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shart. I don't know if he unintentionally put my name on it. So why does she think her name shouldn't be on this? But he sent an email to Mr. Steele and Mr. Shart with me and Simone copied where he said, "This is the communication that I received from Miss Love regarding Mr. Copeland." So this is the forwarded email. My response was, whose interests are you protecting? Yours or Mr. Steele's? Whose clients? Which clients are you protecting? Whose clients? Yours or Mr. Steele's and Mr. Shart's? First of all, it was one line. Why is she saying it 3 times? He wrote back and said, "You're going to get him killed. You are making him a target. Fuck you," is what he wrote in the email. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, his concern has nothing to do with exposure from the state. Yes, it did. Yes, it did, because his email says, I would never have agreed to the terms of that immunity deal. Oh my God, Love. I really think she believes herself, though. Chad, I've got to rely on you again. Did Mr. Melnick express concern about exposure, about something the immunity deal would not cover for Woody? Because Love said here, Mr. Melnick didn't convey to me in writing. It's not his concern. His concern has nothing to do with exposure from the state because of the immunity deal. But then we see the email here attached in the same response. He says, I wouldn't have signed off on this garbage. So let's finish this transcript and let's go reread those emails again. So Judge Glanville says, his being whose concern? Miss Love, Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he's not communicating with us, he's communicating with counsel for the defendants, it would seem that he knows a thing or something that we don't know. Additionally, and I'll let Ms. Bumpus tell you, if he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he's testifying. And we've talked about that. This is, again, a Monday ex parte meeting. He already knew his client planned to go up and plead the fifth. He may have known or had reason to believe that Mr. Copeland was going to lie on the stand. And just part of candor to the tribunal, you're not supposed to let your client do that. So one of the remedies that you have in order to not stomp all over attorney-client privilege is to express that you no longer want to represent your client. And you're not really supposed to go into detail and give away attorney-client privilege information like, my client said this, and that's why I know that I would be violating, my duty to the court if I let him go up there and do that. You can't really get specific. So we've talked about this in depth in the transcript reading, but this was all garbage while Love was arguing this in the ex parte meeting. So they go on to say he's on vacation. Love understands. That's why he has Miss Bumpus here. And he has said what he has said. And as I was reading the statute, I was reading the statute about this particular situation, and I was reading our rules, our ethics rules. So you're reading the ethics rules, but you don't know about candor to the tribunal? Like, what were you reading? Rules of conduct for attorneys. And it is clear that if an attorney, there were 2 things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't representing him. And then, rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shart. And Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. But he also reached out to you. And then you got mad that you were all in on the same email. Well, you can't have it both ways. What we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on, and that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about because we were talking about this case and this trial. And we didn't tell anybody. So, all that aside, we would like an opportunity for the court to address Mr. Copeland with Mr. Copeland's standing counsel present. And then Kayla's going to go on to defend and point out, like, why are you talking about Melnick without him here? Why are you doing that? So, I think we have a little bit more about the email. They're going to talk how long can the contempt, how long can he be held? And this is where they start saying that he can be held longer than just the length of this trial. And Kayla says, well, I'm going to look it up because my understanding is it was until the end of this trial. I know there was one more part where Melnick. Okay. So here Love says, and our concern is that I know the court said essentially you intimated that Mr. Melnick probably told him essentially you should testify. They can't do anything with your testimony. But what we overheard being said was they are going to hammer you as if we were going to expose Kenneth Copeland to. So is she saying in the same transcript, Melnick did in fact express a concern for exposure? In the same transcript, she's arguing, well, he didn't raise any concern about exposure. So she's stating this hammer you, which was not part of the attached correspondence in this filing. It's not attached as an exhibit, this hammer you statement. I don't know when it was said, if it was verbal or in writing. But in this ex parte meeting, Love contradicts herself in between 2 pages. She said he never expressed concern he's going to expose himself, but also we overheard they're going to hammer you as if we're going to expose Kenneth Copeland. And Bumpa says, you heard that? Yes, yeah, Mr. Melnick told Mr. Copeland we're going to hammer him. Guys. And then shout out to Aaliyah, living my best life. That's always good to hear. I'm glad you're becoming a member. Come live your best life with us. And then Victor with the $4.99 says, if Melnick wasn't his attorney, why did he not withdraw formally? Well, and that's the other thing, because you kind of heard Glanville on June 10th ask about, well, did anyone file notice of appearance? Is there a notice of appearance that needs to be withdrawn? But at the same time, I don't know. I don't have an answer to that, but I know that Glanville asked. I don't know. Let's go back to the emails now that we've refreshed ourselves on what Miss Love said on the 10th of June. I think the emails were before the transcript, right? And we're going to be fair, and we're going to see if it lines up. So again, the very first correspondence attached in this exhibit, it has Love in the signature, and it's from Love, it's to Melnick, and it's also CCing in Simone Hilton. This is March 1st, and this is where they're talking about the bond order. Go ahead and get it signed. And then also on March 1st, Adrian sends another email. So we have one from Adrian, and we have another one from Adrian. Again, talking about the bond order. March, again, still waiting on Mr. Melnick's response. And then on March 3rd, again from Adrian Love, we're asking that the defendant is required to sign on the conditions in front of a notary or sheriff so that we can enforce the conditions upon his relief since he was not apprised by the court in person. And then we're back to June 7th. So June 7th, we have Jonathan Melnick saying, here is a communication between myself and Miss Love which pertains directly to the YSL case. So he's showing, look, this is relating to this, and I was clearly representing him. And then in response to that, he's also telling just Simone and just Adrian at this point. No other attorneys are CC'd here. My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. What does this mean, you guys? What does this sentence on the screen mean? What does the sentence on the screen mean? It means we're concerned about exposure. Because the deal that they want to give him, I would have demanded something much stronger. Because this gives too much exposure. And then we have in the transcript, he never expressed concern about exposure. Oh, but he also verbally, we overheard it. So it had to be verbal if it was overheard, right? You don't overhear an email. But we also overheard him say he was going to get hammered, and that could expose you to, oh, wait, we're going to stop ourselves from talking. Seems to me like Love and Hilton would benefit from Kenneth Copeland not being represented. And to play dumb, saying, well, we didn't know he was represented. Because if Melnick actually got to see this agreement before we got it pushed through, he would have put up a fight. He would have put up a fight before we got Fonnie Willis to sign off on it and before the judge said, all right, now he's got to testify, and if he doesn't, we're going to hold him in contempt. Like, this is a little bit crazy. This is a little bit crazy. And I agree. So I think that this is really interesting too. So, but I do think at that point, technically, Jonathan Melnick is sending it to Love and Hilton. But yeah. But that's exactly why. That's exactly why he should have been present before this became a problem. And then on Monday morning, they spend another good 30 minutes, which is Hilton talking to Kenneth Copeland while everybody else is waiting in the chambers. So I don't know. I really think this and play devil's advocate in the chat. I don't mind you guys. You guys can play devil's advocate with me. Do you guys think this was a strong argument? Try to pretend we don't. I know most of us in the chat, not all of us, but a lot of us have been, as a group, critical of Adrian Love. Can we play devil's advocate here and say, you know what, actually, if we step back and look at this from a clean slate, this is a good argument. Don't clip me saying this is a good argument. Don't take it out of context. Don't do that to me. But I mean, we have certain underlines and emphasis here. It should be denied because even if assumed to be true, it wouldn't authorize recusal. But we just saw Judge Christina Peterson, the Supreme Court handed down a ruling that she needed to be removed for really 4 core reasons. And one of them was because her clerk engaged in an ex parte communication. It was her clerk. And now Love knows better than the Supreme Court. Adrian Love knows better than the Supreme Court. Julie, I'm with you. If you step back, this is worse than we thought. Justice Matters says the argument is trash. Daniel says stop being nice. No, I'm just, I'm trying to, I don't know what I'm trying to do. And then Empress Fox says, how can they say they didn't know he had a lawyer on Friday when this email exchange happened? Then they said they didn't know he was pleading the fifth. This is crazy. It just goes all over. And Ollie, yeah, let's do that. Did Brian Steele, I still have those other motions open. Did he come up, bring up the emails again? I'll pull up the supplement. But I don't think we got any new exhibits with Brian Steele today. Yeah, no new exhibits from Brian Steele today. So let's pull up the supplement. Because it was a slightly different. Nick Starro, do you want to come up and gripe with me? Thank you so much for your super chat, Nick Starro. I will drop a link if you want to come up. I'm actually going to send it to you on X. No pressure, but would love to have you just shake your head on screen with me. Okay, so just sent you the link. And while I'm on X, Tish, if you're in the chat, Tish left a reply on X that says 9 pages with lots of unnecessary underlines and bold font. I agree, I agree. Oh my goodness. And yeah, so real Doc Dre, that's a good point too. How can we say attorneys were CC'd? We do see that. I'm going to pull up the other emails from the supplemental filing from Brian Steele. There is some CC'd emails in that. But yeah, it's like sometimes there is a basis in what Love is saying, but she'll jumble it. So we'll get something that's kind of like somebody was CC'd in an email somewhere. Well, that's true. But she'll ramble between like four different sentences in one paragraph. You could see different parts of the transcript where there's dashes where the court reporter couldn't keep up. And she'll switch from like, well, someone was CC'd, well, the email, they said, and it just doesn't follow. There's no logic behind it. She blathers about the facts and tries to put an umbrella argument over it and hopes that nobody will look at the underlying facts to see that they don't add up to how she's saying it. And then, yes, let's do that, Victor Man. We are going to look at those emails. And shout out to Angela for also becoming a member. Being a member is fun. You get to pick Mario Kart emojis. Man, let me pull up this other document. I've got so many documents from this case, and that's Brian Steele's fault. All right, and this was the 233-page one, so I should have, I guess if I just search Melnick, maybe I can just get right to some of the emails rather than taking you guys through a bunch of pages. Okay, cool. So let's get to the top of this exhibit. Well, let's go to the bottom. So we'll go in correct order, right? So this is the earliest, not the most recent, attached in the Brian Steele supplement here. So from Melnick to Adrian Love to Simone Hilton to the Steele Law Firm and to Max Shart. These aren't CCs, it's to all four. So good afternoon, all. It has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick. Now, what's interesting about this, because again, this is Thursday. This is before the Friday. And then that's at 4:31 p.m. And if they were already planning this immunity agreement, why would it be a problem for the defense to be in the loop at this point? Because under Giglio, you need to inform the defense about any possible deals or offers or agreements conferred upon a witness, because that could impact the witness's credibility. And the defense has the right to know because they need to be able to properly cross-examine him. So I'm not sure why she was raising hell about them being CC'd, and they're not technically CC'd, but whatever. Maybe that's just misspeaking. And then we get, again on Thursday, but at 5:48 p.m., again from Jonathan Melnick, to all four, and also CCing Antonio Long with the Fulton County District Attorney's Office. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Miss Love early in the process around the time jury selection was beginning. I have a plea with Judge Carnsdale tomorrow at 9 a.m., and I will come into the courtroom as soon as I'm done. And he sure did. He sure did. Angela, good to see you. This chat is moving so fast, but I saw that just by chance. So we know he came in that day. Oh, and he's responding to Hilton here. I missed that one. So this is from Hilton. So how come we don't have... So I think this seems like Melnick. Do you guys ever open an email and you highlight everything and delete it and then start typing your reply? It looks like he may do that intermittently. So we do have this, but it doesn't have all of the reply. We just have this one bar here. So there's actually this response in between these two from Hilton that says, "Good afternoon. Hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease our communication. But your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we were planning to pick him. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. Yours in service, Simone Hilton. So there you go. And actually, so this was sent on 8th. This is so it looks like on the 8th is when Brian Steele or Max Shart. So Max Shart sent this communication. You guys see this at the top here? So from Max Shart, forwarding correspondence about Kenneth Copeland to someone at Brian Steele's office, Courtney Edwards, on the 8th. So this was all copied and pasted maybe from Shart, which is why it looks a little bit funky. Just a little bit funky. And then let's see what you guys are saying. 'Cause, I think there's a lot to say. Let's see. Yeah, I mean, that's apparently clear. Like, Miss Love didn't want defense there. There was no reason that the judge couldn't have just said, "Look, let's just call a defense in. Let's have someone. Let's let them know that they can be here, and let's just do this right." But Judge Glanville didn't. So, as much as Hilton should kind of know better, Judge Glanville also could have made that call, which is why it's interesting that the state is arguing to defend Judge Glanville in their response today, the response that they filed today. And yeah, I agree. They knew. I was reading the comment and disappeared. I don't know, sometimes that happens. Sometimes people can retract it too. I would totally stream with Cuffboy. I saw like a stream where he brought his mom on and I thought that was hilarious. They were reviewing, I don't remember what it was, but they were reviewing a song. But she was really observant. And then let's see. The state's doing as they please. The judge never even gave the defense a copy of Woody's immunity order, and they didn't give it to Kayla, and they wanted Kayla to just be completely ready. They just wanted her to completely catch up with the speed. At that point, they had no excuse to say that they didn't know Kayla wouldn't know the whole case like the back of her hand or anything that if it was just a witness that was going to speak about one thing, like a Hertz car rental, maybe you don't need to know everything else. But they want Woody to testify about hours and hours of videos, anything that those interviews entailed. It's not just a small little scope. So for someone to be able to come in and know, well, does he have exposure? If he goes up on the stand, is this deal tight? Is this immunity agreement tight? What should he be cautious about? What should the state be cautious about speaking on because he wouldn't be covered by their use immunity agreement? How could Kayla ask those questions if she didn't have a chance to get caught up to speed and also see what the agreement did or didn't cover? So that's a huge point. And that's something that really to me, that's really where you see the shade, right? You don't contact Melnick, you just want this immunity deal to fly by, and you want Woody to go up there not knowing any better and say whatever you want him to say without thinking, without realizing an immunity deal isn't a blanket cover for all forever. I really think it was sneaky. And Ghost, thank you so much for gifting memberships. If you guys got a gift from Ghost, say thanks to Ghost in the chat. If you guys want to just say Ghost because you appreciate Ghost, do that too. And then Victor Mann. They wouldn't need immunity until after they knew about the fifth. So why didn't they communicate with Melnick? I don't know. And likewise, why would they be upset that Steele and Shard are in an email finding out about the immunity agreement that they're going to have disclosed to them at some point anyway? You know, the state and the judge, I do think they're on the same team. And I love that argument that Steele made in his own filing, his supplement. Let's see what you guys are saying. And hey, Heart of Inspiration. And we've got a holy crap, but I don't know what it applies to specifically. And Randa, or maybe it's Rhonda, says a lot of it's iffy with a lot in all caps. Let me check. And in all seriousness, just because it's not stamped in one place doesn't mean it's not signed and sealed. Where was this long but not long argument? I guess I could just search for Connie. Oh no, the exhibits aren't OCR'd. I can't search for it. Well, let me find it and then we'll switch over to it. Now you guys don't have to watch me strobe light scroll through 200 pages. Okay, so signature, and that's the end of it. So not this copy, no. No, but I mean, maybe they've got one with a proper seal on it where it should be. But and heck yeah, Pam, this whole case is shady. I don't think there's any turning back from it. And then does this show up on the docket? Um, I got this from Jozsef Papp. It has the timestamp it's filed. I can double check. And let's see. Yeah, so I'm seeing it on the docket here. It's gonna be like really tiny on the screen, but it's in reverse order. So the bottom one was the most recent filed. So you can see them here. This is under Jeffrey Williams, so it's not going to show the Doug Weinstein filing. But yeah, so that's there. And then you guys, there's no doubt. Um, and what's the problem? Say Woody didn't tell them this. Woody could tell them that he told them either way. So even if that's made up, Woody never said he was going to plead the fifth, and he just dropped a bomb on them the night before or whatever. He could still come out and say, "That's not true. I did try to tell them for a week and they kept badgering me." Whether it's true or not, he could say that. And it would be, testimony. It'd be a statement on the record. And I always wonder that too. So this is a good point. So Just in Time says, if that crap love scent gets the recusal denied without a hearing, this will suck all the air out of the defense. They will never get a fair trial. I honestly think that these attorneys will not lose steam. I think they're pedal to the metal until it's done, even if done means a year from now. And that might not be for all the defense attorneys, but I would say it certainly means that for Steele. Probably Glanville, not Glanville, probably Weinstein at this point, probably Shart. Keith Adams too. I don't think Keith Adams liked seeing Brian Steele be held in contempt. I think Keith Adams is burning too. Like, he was not okay with that. I think he was like a bit in shock while it was happening. If you kind of like watch his demeanor, I think Keith Adams was in shock a little bit that that was really happening. And yeah, I think it's going to go back to the Supreme Court because again, so Judge Krause is not recusing herself, but I do think she wants to look at the arguments and the law that's available. She wants to look at the case law. And we have a very recent ruling from the Supreme Court about Judge Christina Peterson and an ex parte communication violation. We also have the Supreme Court whispering ever so gently that, hey, if this recusal motion for Judge Glanville, you've got to take it back to a Superior Court judge first. But if you don't like the resolution of that, appeal it right back up to the court. Come back to us. So I don't think this ends here. And then, yeah, let's go play that. You guys want to play the 12-minute clip or however long it was of a shoulder shrug. Let's see exactly what's in that long clip. Where was that footnote? Hopefully it was clickable. Was it this one? Yeah. Let me pull up YouTube. Oh, the URL isn't actually the timestamp. So what was the time on it? All right, so 1 hour and 12 minutes and 50 seconds.
Had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021
Shout out
about
to
this
Big
matter.
Tit.
And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding
on this law and crime
bond
feed
for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And
why did she
we very
timestamp this?
specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case.
Played a lot too around this.
So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify. Mr. Had conversations about Kenneth Copeland.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are. I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was going to invoke his Fifth Amendment privilege. So
absolutely knew it.
So, but in order for them to still get this testimony, which they believe that they need, they offered him immunity. So that's what we explained to your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you probably, and I know you, I've known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with them, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is it your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
I've known you for almost 2 decades. I've known Miss Hilton and Miss Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland. About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
when did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that.
This is Friday already.
Melnick had told Ms. Love that he wasn't his attorney.
Hold on, we've got to pause there, because every time we watch this, it gets more ridiculous to watch in retrospect, right? You could kind of get the vibe that it was funny while it was happening, right? But we've looked back at this, we've seen some stuff. I know Julie's she's gonna be like, oh, I already know what Kat's gonna say. But Hilton, we see in the transcript, you were speaking to him at least 2 weekdays this present week, the week leading up to Friday, June 7th. And now Glanville asks you, when's the last time you talked to him? And you say, last Friday. Like, put this in your footnote, love. Timestamp this. And there's so much here, guys. That's just one detail that I didn't really pay attention to, but there's a lot here. They stomp all over their toes. It's clear they knew he was going to plea. They're trying to find a way to act like they didn't know Woody wanted an attorney or that Melnick could have been contacted.
So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays, when we picked him up for the first time, on Tuesday, when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home. And then yesterday, he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client is going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid, or may not have thought
it's
that
the
he
witness's
potentially
fault.
needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not
And Adrian is my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to.
So wait a minute. And I wish Kayla was here right now. But Kayla said that, since she did one thing with this case, she's getting pings about all the docket updates as they come in. So that leaves me to question, if Melnick did something previously with this case, did he get any type of pings, docket updates, that something was funny? Like, he obviously became aware in some way, shape, or form that Woody was coming into the picture. So now I've understood the idea, the concept. Bear with me, guys. I'm piecing together the smaller details. I'm piecing together the concept that they knew Melnick was going to be out of court, because they could have seen that for any case, right? He could have told, this other case I'm working that I should be here for on Friday, I'm not going to be available. Adrian Love and Simone Hilton could have become aware of that. They put in this last minute notification thinking Melnick won't even see it, forgetting that he could get a ping about a new update in this case. Either way, he became aware of it. And Nick Starrow's right. This is an issue that's happening in several cases. It just happened with Courtney Clenny. It might be happening with Shayna Gardner. That was another case in Florida. Courtney Clenny's in Miami-Dade. Shayna Gardner's in, I think, like Jacksonville. She was the one that her boyfriend, they hired a killer, a hitman, to kill her then husband. And then the hitman confessed to it all. But there's these privilege violations going on where someone was represented by counsel and the state is going through communications with the counsel and other people that are involved, where there's multiple co-defendants. In Courtney Clenny's case, it involved the parents. They were discussing not just the furtherance of Courtney Clenny's defense, which is protected by attorney-client privilege, but at some point, Courtney Clenny's parents, and I'm saying this as someone who thinks that Courtney Clenny does not have the self-defense justification in her case. But with Courtney Clenny, at some point, because her parents were witnesses, they also became represented by the same law firm. So there's two different angles by which attorney-client privilege would have been in place. But the state prosecutor, Khalil Quinnen, directed the taint team, the filter team, not to filter the images, the communications. And they looked at messages that were protected by attorney-client privilege. They had an inside look at the defense team's strategy. And Judge Laura Cruz said, nope, can't happen. We're suppressing that evidence. And now they're going back and forth with motions to possibly recuse the state prosecutor's office from trying the case. Insane. And the state shouldn't be doing that. And the argument there was, all you guys had to do was either contact us, the attorneys, or look at the paperwork and just let your filter team do the proper job. Melnick was already involved in this case with witness Woody Copeland. All they had to do was look. So Nick is so right by saying they chose not to look on purpose, because they would have seen, oh, it's not blank. No attorney has ever been involved representing this witness before. So they chose not to look. They opted away from diligence. So,
But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time, is that Monday morning, I will bring Mr. Copeland back out. It is,
now this part right here is what Love, in her 9-page argument today, her response, this is one of the 3 arguments she's hinging on, is what is discussed here.
don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial. Because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time.
Okay.
And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay.
Judge, I have some personal matters.
So he's going to go into, Melnick's going to go into, he's not going to be here. He's got to find someone to stand in. He ends up finding Kayla Bumpus will do it. But really, Love tried to make this argument that the ex parte was okay because they said that they were going to make sure Monday morning that he was going to testify. If it was okay, and if you already made them know, then why was it a problem when Brian Steele tried to inquire what you guys were doing for like 2 hours worth of time, 2.5 hours worth of time? So again, Love is arguing that it's okay because they knew. But it was also so disturbing and crazy that Brian Steele inquired and refused the orders of the court by asking to know what happened. So did he know or did he not know? And we're going to go, if you guys weren't here in the beginning, we did look at we got through most of the one filing from Steele. We talked about how he filed an amended witness list, an updated witness list that now names Judge Glanville. No one's surprised that happened. It also named Adrian Love and Simone Hilton. Let's, which one were we on? Got so many tabs, you guys. It's insane. Supplemental motion to recuse. Got one of them here, which was this one. That wasn't the one that we were reading. Let me pull up the one we were in the middle of, and we'll finish that one. Yeah, I still think it's funny that we have an updated witness list. They're named. Like, if the trial ends and they never start back up, their names are still going to be on the witness list. All right, so we were a few pages into this one. If you guys weren't here in the beginning, this is a new filing from Brian Steele today. It's a motion for both a fair trial as well as a motion requesting a list of any other dates and persons involved in any other ex parte communications throughout the time frame of this trial. And it's also a motion for mistrial based upon both judicial and prosecutorial misconduct. So no retrial. So we got through a lot of this already. And I I believe we were here. Let me zoom this in. And before we do that, I do also want to thank you guys. You guys are being so supportive today, and I appreciate you. I'm still getting used to toggling between super chats and the screens and making sure I don't miss you guys. But yeah, Victor, I think I may have covered this, but they wouldn't need immunity until after they knew about the 5th. So why did they communicate? Why didn't they communicate with Melnick? And then Victor, this made me laugh reading your name. But you had said while we were watching the video that y'all remember the state didn't want Woody's name mentioned as the next witness. But the defense baited the judge into asking if he would be testifying. And Dre has really summed up this point a few different times, but that's a good possibility that that's why Melnick interjected himself, according to the state, Thursday evening. They're acting like it just came out of nowhere for no reason. But the timeline is there. It's kind of self-explanatory. Garrett says new team lineups, DA Glanville and Judge Love. Okay, well, what? They're switching the roles. Can you imagine Judge Glanville leading a cross-examination or direct examination even? I think he'd just get bored. He'd call a break in the middle of his own witness testifying. Thanks for becoming a member, Victor. Peguardo says, I think the first emails were regarding the bond conditions from another case. Yep. So it might have been from another case. I'll have to double check that. It could be from another case because Woody had, several things going on. But still at the same time, that's still a pretty recent correspondence. It's in the same district. It's in the same court system. They could have looked. But if that's accurate, it's always good to be more accurate and get the details there. And guess who the judge was? Oh my God, wait. So the judge for Woody's other case? Was it Krause? Was it Krause? I see the K. And Garrett says Melnick was his attorney for a bond issue with Judge Krause. So this is the same. Guys, I don't know. I'm a mixed bag on Judge Krause. I really think from the orders that she's looking for someone to give her the argument. Give me the argument, give me the things that I need, and if it's meritorious, I'll fight in favor of that. But I do understand corruption runs deep, and I do understand that, she works under Judge Glanville technically. They could be friends. And even if someone doesn't mean to be impartial, they might not realize that they could be impartial. And I guess also on the flip side, someone could try to overcorrect an appearance of impartiality and kind of favor the other side to correct for it. So I have to wait and see everything with Rachel Krause play out personally. My optimism lies in, the comfort from the Supreme Court saying, hey, if you don't like the resolution, after the Superior Court judge, whoever gets to look at it, looks at this motion to recuse Judge Glanville. If you don't like the resolution, just come back and see us. Come see us. That's really where my comfort lies. And then Rod Factor with the shirt that says ATL Ho. Thank you so much for the $49.99 super chat. 80 Love makes me cringe. Every time she speaks, I hope this case causes Fani Willis to lose her re-election. I think it's hard to get rid of an incumbent no matter what they do. But I understand. You guys let me know your thoughts in the chat. If you think what we're seeing going on, we're going to keep it to the scope of the YSL trial. But the promises that DA Fani Willis came into office with, when it came to indictments and doing things that are better for the community, do you think that this is the best way to accomplish that mission statement, those campaign goals? Because if that's some of the reason that people voted for her, it could be a very big problem for her reelection. It depends on what platform they care about the most. And I appreciate your support for the channel, Rod. If you guys haven't tuned into some of the smaller things, they're big things, but they're smaller news stories in Fulton County. The ACLU, 3 different attorneys from the ACLU of Georgia and an organization called Barred Business, they filed a petition for a writ of mandamus back in March of this year. I think it was March 21st. They were taking issue with the fact that there is a very high number of people sitting in Fulton County jails without an indictment. And according to code, if they're there for 45 days sitting without indictment. It's time to notify a judge, send a note to the judge and say, look, this guy still doesn't have an indictment. We need to get it on the calendar to have a bond hearing. It's required. That's what the DA's office must do. And the ACLU sent records requests to the DA's office. And they said, look, we're looking for copies of notes sent for these people that have been sitting there for more than 45 days, really more than 90, without an indictment. Did you notify the court as you're supposed to that they need to have a bond hearing scheduled? They tried twice, and both times, we don't have the responsive documents. What does that mean? We don't have the responsive documents for a note that we're supposed to be sending. Might it be that you're not actually sending the thing that you're supposed to be sending? So they filed this petition for a writ of mandamus because they want a higher court to order Fani Willis to do what she's required to do. She platformed on this, reducing people sitting in prison without indictments. She has an entire pre-indictment diversion program that she made a PowerPoint presentation to help secure an additional budget for. Like, it's crazy, 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 crazy. It's crazy. So if that was an important part of her campaign, I don't live locally to have a pulse on what people are saying. But if that was an important campaign message that people related to, that resonated, and it compelled people to go out and vote, we would love to see more indictments diverted. We would love to see people actually brought to justice, whether that means they get convicted or they're acquitted, whatever the case may be. But stop this limbo where people are sitting and we're paying to keep them in the Rice Street jail. If that's the part of the platform that resonated with people and that's not playing out and people are becoming aware of it, I think it really could impact the election. But I don't know. I don't have a pulse. I don't have a pulse on it. I know she won her primary though. So, but I appreciate you again. And I also appreciate the opportunity to go off on a tangent because I really, really dislike the idea of someone being held in custody indefinitely without just cause. Can you think of a worse violation of your rights than being stuck for more than 45 days, more than 90 days, sometimes more than a year? Someone was stuck for like 436 days, and they actually had a hearing in front of Judge Glanville about it. This is in September of 2023. And Judge Glanville is like, well, now that you told me, I can do something about it. So, maybe we'll start holding courts on Saturdays and start moving this court calendar. We'll start moving things through. Do you guys think that ever happened? If they had to file this petition for a writ of mandamus in March of 2024? Judge Glanville said, we'll speed up the court calendar. We'll move things faster. It was Judge Glanville that made the promise. So, but let's get back over to the Steele motion, you guys. And shout out also, so Garrett was saying Woody was on TLA and said Krause violated his civil rights. And that was talking about, they didn't want to give him a ankle bracelet either, right? They were saying that they didn't even try to offer him one. So maybe it was Melnick that asked, like, can you give him an ankle bracelet? And then they denied it. Guys, that was good too. So if you go to the lead attorney's stream yesterday and scrub through, use the timeline, look for when Woody pops up on the screen, because Woody spoke a lot about prior cases in Fulton County. He also spoke about a case that went up to the feds, but it was the state that provided the case file, and they turned it over to the feds. And part of that case file involved what Woody's saying was video footage that was clearly chopped up, missing pieces. So really, really, really lots of details that if I'm trying to repeat them, I wouldn't get right. So definitely shout out to that stream. It was long. It was like a 7-hour stream. So you'll want to look for Woody if you want to see that part. And then Dante with the straight up $5. I appreciate you. And I'm going to butcher your last name. Bagnasco. I need a Hooked on Phonics for name pronunciations. And then Albert Edens is now a member. Welcome. Make sure you choose your Mario Kart racer. You have special emojis now. But this Brian Steele filing, we were just talking about, she shared this demonstrative aid during her opening statement. After she turned over last minute the demonstrative aid that she was supposed to use, she turned it over at the last minute as she's supposed to, and then still showed a different demonstrative aid. During opening statements, like a couple minutes in, Brian Steele moves for a mistrial right then and there because of that. And then during the same opening statement, Lawyer Love once again defies another court order, introducing to the jury that undersigned counsel had represented other people charged in the case. Because up on a PowerPoint presentation, this thing that it was like 4 slides and then it became 60, they have the attorney's name with the person they represented on this PowerPoint slide while they're showing it to the jury in opening statements. So right then and there, they're like, oh, we object. But again, no consequences were meted out by this court. Then Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Mr. Bean was taken to the hospital. They called a bench conference during this time that this was happening. This was back in the spring. So this is a few months ago already. Love was saying, we have evidence on her table that proves these defense attorneys are lying, that they're fabricating evidence, and that Mr. Bean never went to Grady Hospital on September 11th, 2013. Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally and knowingly false. Yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. Now, this is great. I'm glad we stopped reading this to go over to Love's argument. Because what do we see Love say in her argument? There was only one instance where anyone in this court wagged a finger over at the defense counsel. But right here, going all the way back to March, we have a pretty clear example of the prosecution accusing the defense of fabricating evidence. So already, this filing that Steele slipped in through the door today gives extra examples contrary to Love's assertion. It only happened one time. Then over Mr. Williams' objection, when the state was attempting to introduce the January 26, 2015 social media posting from Cohen's I.D. Garlington, his account about the testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video and audio, except for one other voice saying words like, yeah, in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons' voices were audible in the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, Lawyer Love was proven... Of course, Lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct and lying to the court did nothing to admonish Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongfully favors Lawyers Love and the state of Georgia in this case. Maybe we'll watch this clip too. This was a bunch of back and forth, but since they give us the timestamps here, maybe we can look at that after we're done reading this, because that was a day too. On Thursday, June 6, 2024, as well as Friday, June 7th, 2024, Lawyer Love falsely accused undersigned counsel of purposely extracting and tampering with jail records of Mr. Copeland. This was another knowing, malicious, false allegation by Lawyer Love. The court remained mute and failed to admonish Lawyer Love. And we can watch some of the June 6th clips here too, if you guys want. You guys let me know in the chat if you do want to watch any of these clips after. We're not going to keep beating June 7th over the head. On Friday, June 7th, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being, quote, unprofessional, as well as, quote, unprepared. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, as undersigned counsel was neither unprofessional nor unprepared. Now, what's interesting is at the beginning of this, and this is nice, this is a shorter filing from Brian Steele than what we normally see, but because it's short, you can keep the bullet points closer to the forefront as we're going through it. So in this paragraph here, well, they're criticizing me for being unprepared, but the very first issue I raise in this filing is you went from like a 4 to 6 page presentation to like 50, 60 slides. And then you're going to call me unprepared when you have a duty to provide any demonstratives ahead of time. You're making it so we can't be prepared. And then in open court, you're calling us unprepared in front of my client and in front of the jury. And then this court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel, and its refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias for the state and prejudice against Mr. Williams and or his counsel. And it'd be a little bit different, guys, if Judge Glanville treated the state the same way. If you guys have watched a lot of the trial, have you seen moments where, on the flip side, Judge Glanville has done the same thing to the state? Because that's where it becomes an issue. A judge has discretion. A judge isn't going to have, a strict guideline of how to rule on every single objection made, for example. But they have a window of discretion that they can use. But if the needle always leans in a direction that favors one party, now it becomes a more questionable issue. These above few examples raise reasonable questions concerning the court's partiality and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. This court's impartiality is objectively questioned, and the court must be recused. So see, for example, and they cite Johnson v. State. This court has falsely and wrongly accused undersigned counsel of being unprofessional and unprepared in front of the jury. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongfully and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Mr. Williams. The court has violated its duty of neutrality, impartiality, that it was even sworn to undertake. Even knowing that the court has falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. This conduct shows that the court is biased against Mr. Williams and or his counsel and favors the state as no unbiased judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. And then, to date, the court has done absolutely nothing to stop Lawyer Love from continued misrepresentations, abuse of others, and false allegations. Instead, on one occasion, the court speaks in generalities and reminds both sides to be professional. And we watched that. That was recent. Because remember, when they tried to call it out, they're like, no, this has been done by both sides. It's been both sides. And here, Steele says that this is not a both sides issue. This is a one-sided issue. And for clarification, we also put a 1 in parentheses. A one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional right to a fair trial. Mr. Williams languishes in jail without bond since arrest on May 9th, 2022. Mr. Williams has been and is being denied his constitutional right to due process, fair tribunal, and a fair trial based upon prosecutorial and judicial misconduct. The court has exhibited a pattern of bias in favor of the state and against Mr. Williams and or his counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. This failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. And then now we're going to get some of the same arguments we saw yesterday, you guys, but the court has effectively joined the prosecution team. And who was joking in the chat that they're switching roles? It's going to be Judge Love and DA Glanville. So they did this by permitting Lawyer Love to defy court orders without consequence. And they gave one example here, right? You've got to give examples. You've got to show what you're saying. So one of those examples was, hey, there was a court order in place that demonstratives must be provided to both sides. If you have a demonstrative, you got to provide it to us. Love didn't do that. The court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received a constitutionally mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the misconduct of the prosecution and the judge. Because the state has blatantly violated Mr. Williams' rights and goaded Mr. Williams into making motions We've seen many motions for mistrial, all of which have been denied. The above few examples are egregious and cast a dark, ugly stain onto Georgia's justice system. The below further captures the violation of laws that lawyers Love and Hilton and the court display herein. And this is where we're going to get the argument about the immunity and the ex parte. So on Monday, June 10th, we already know, you guys, the court is in there too. It's the judge and it's lawyers Love and Hilton, and they have this ex parte meeting with previously sworn witness Mr. Copeland, so he's already sworn in, for whom an order of use immunity had been issued on Friday, June 7th, 2024. No notice of this ex parte meeting was provided to any attorney for any of the accused on trial. In fact, the accused and their counsel were wholly unaware that the Star Chamber meeting was occurring or had occurred until well after the fact. Mr. Copeland had previously been called to testify on Friday, and he asserted his Fifth Amendment rights in front of the jury, and as such, he was held in contempt, and he was incarcerated over the weekend until such time as he agreed to testify, pursuant to the order granting use immunity. Once undersigned counsel confronted the court with a motion as to why the court held this impermissible ex parte on Monday. And this is where it becomes a problem, because you have the chance to tell us. You have the chance to promptly disclose. But what happens? Even though they eventually admit that this meeting had in fact occurred this morning, this admission only occurred after undersigned counsel revealed, based upon information and belief, that this impermissible illegal meeting occurred. It wasn't disclosed. It was, exposed, if you will. Undersigned counsel proffered that statements were made to and in Mr. Copeland's presence by the court and or lawyers Love and Hilton, all acting in concert, asserting that Mr. Melnick failed to represent Mr. Copeland's interests, and 2, explaining the amount of time that Mr. Copeland would be held in custody unless he testified, as urged by lawyers Love and Hilton and the court. Also on June 10th, the court denied undersigned counsel's request for the transcript. And they also denied undersigned counsel's timely motion for mistrial based upon, but not limited to, Mr. Williams' federal and Georgia constitutional and statutory rights. And we know what those are at this point, guys. Fair trial, fair tribunal, ethical prosecution, all the things. And the right to be present at every critical stage of the proceedings. But instead, the court decided to hold me, Brian Steele, in contempt and ordered me to spend 20 days in jail, despite the assertion of valid privileges in declining to answer the court's demand to reveal the supposed source of information about the ex parte meeting. So, in the afternoon of Monday, June 10th, Love and Hilton sat mute and permitted this travesty of justice. Lawyer Love argued, hold on, guys. I can't read the same thing over and over anymore, Brian Steele. So later, Lawyer Love argued that ex parte conversation with sworn witness Copeland was ethical, just, and proper. And I think she argued that today in her response, despite it violating multiple constitutional provisions, judicial canons, and rules of professional responsibility. And then furthermore, Mr. Williams' request. So this is where we want. This is why this is important, you guys. We want this mistrial. We want a fair trial. And at this point, you need to tell us, what are these other persons that you may have had an ex parte meeting with? And we get this little if any. But this question, we're asking for it because we expect that there's more. So Mr. Williams requests a list of persons involved, the topic of the same, and a transcript of all ex parte meetings conducted by the court involving anything to do with this case or trial. Additionally, Mr. Williams also moves that any document that is filed under seal be reviewed by a neutral judicial officer to determine whether the same needs to be unsealed and shared with Mr. Williams. So we don't just want to know about ex parte meetings. We want to know about anything that may be under seal that you're saying there's a reason to be under seal. Because now we can't trust that. We can't trust that. Yeah, I need a comfort break, you guys. What was it? Was it June 10th? Was it that Monday that Judge Glanville started chomping and suckering down on a cough drop or something. It was some point that the attorneys were trying to proffer their argument, and he was all up in the microphone like blah 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 blah. like of all the times he didn't take a comfort break, he just decided I'll just chomp up on the microphone. Yeah, this is a pretty big question, you guys, because in the header of this document, in the title, we're asking for other ex parte meetings. What haven't you disclosed to us? But also, there's stuff that's filed under seal. Someone else should review those things. So wherefore, and we're almost done. We can look at some clips, you guys. Have a comfort break. And it probably was a Cherry Halls. Undersigned counsel respectfully requests that Lawyer Love be barred from uttering false allegations or disparaging words. That's hilarious. Toward anyone else, I guess. I thought for a second, did you guys remember that clip? Did you guys watch the stream or see the Cuff Boys clip where he called out where Love and Hilton were fighting over the microphone? It'd be funny if they were ordered to stop doing that. But 2, Lawyer Love, conduct yourself with professionalism and in full compliance with the Georgia Rules of Professional Responsibility, which govern the conduct of lawyers in the state of Georgia, if able. And 3, a mistrial be declared based upon Lawyer Love, Lawyer Hilton, and the court's failure to protect the above stated constitutional rights, as well as Mr. Williams' right to be present, for these critical things, to confront the witness. We also want Williams to have the right to the fair tribunal, right to the fair trial, right to due process, and right to present a defense and call witnesses, including the ones we added to the witness list today. So, signs off, Brian Steele, Keith Adams. And then is this the one for the demonstratives? Or, let's see. This is the order back from July of 2023, but ordered, finally signed off on November of 2023. So we can't mention that Steele represented another person. So talking about that Blaylock mention that was in the PowerPoint presentation during opening statements of this trial. We made it halfway, not even into opening statements. And we had a violation of a court order. So they attached that here. That's the receipt for that. And that's good timing if you ask me, Barbara. You also missed me like half choke out trying to read. And Red Bunny, don't give us the imagery. Shout out to AM and Mia Joseph becoming a member right as I choke out on stream. Thank you, Mia Joseph, for the $5 super chat. Say thanks, Kat. You're the best. Love how thorough you are. I feel like I'm not being thorough because I'm not stopping to play all these clips, these little things in the bottom. I really love some of these video clips, you guys. The June 7th one, I've played like 5 times, and it gets better every time I watch it, just to watch the attorneys, the district attorneys, lie. We already know what they knew the day before June 7th even started. And we know what they're going to do on June 10th. So watching June 7th is just incredibly hilarious. And then shout out to Moses for becoming a member. And then also Chance says, love your content. Queen Kayla B, shout out. I don't know if Kayla's still in here, but I'll literally screenshot this and send it. Make sure she sees. I like Kayla B. If you guys didn't see, there was a small rift between her and another defense attorney, Rachel Kaufman. Right? Yeah, Rachel Kaufman, not Rachel Krause. I almost confused them. But they ended up having a great stream yesterday. And they talked about, different cases that they've been in. They've given us a little bit of insight on different judges. Just some little boots on the ground insight. And Infamous Sylvia also joined up, and so did Nick Starro. So it was a really, 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 really good panel conversation. So it's been really nice to get some insight from Kayla B. She didn't ask to be put in the position she was put in. So shout out to her for, being able to provide some context, give us some answers and insight. She did hit the brakes a few times, but that's of course understandable. And then hold on with the bars. So hold on. Garrett says, Love's response was late, so YSL must skate. Oh my gosh. And then Dante said, unfortunately, Fulton County has not voted Republican since Richard Nixon in 1972, so it is very unlikely for Fani Willis to lose her reelection. I really think it's hard for any incumbent to lose a reelection, you guys. I think you've got to, like, I don't know, like slap a baby on camera, like something that's so obviously heinous. But I also don't think that the party lines really mean all that much anymore. Sometimes party affiliation, especially when you're speaking with a politician's going to go up there and they're going to speak platitudes. They're going to say these things that sound like what they think a pool of constituents wants to hear. It's going to sound good, but it's really probably meaningless. It's not really going to play out. So I honestly don't think that it matters what parties where. I think no matter where you go, someone's going to say the right thing and they could get elected into office, and they could be absolutely the opposite. Fani promised pre-indictment diversion program, and we didn't get that. But it sounded good. It definitely sounded good. On the surface, I support it. But the way it's playing out, so everything to me is platitudes. I don't really do politics too much. And then Drea, so Maurice Jimerson, is this Fulton County 10 years? You're kidding me. Hold on, I'm going to Google Maurice Jimerson. And there's a little battle over, a bill was signed to block charity organizations from paying, and this is Georgia, the state of Georgia. But a bill was signed and a federal judge put a hold on it. I think it's like 14 days, but that was a few days ago. So we've got like another week left on that. But they want to cap charity organizations from donating only 3 bonds. They can't pay for more than 3 bond payments for people in a given calendar year. So the bill was stopping that, and the federal judge is like, hold on, before we put this bill into place, we've got to look at that again. And that's kind of crazy, because what if you have a whole organization, something similar to Barred Business, who's trying to raise money to help people that can't afford their bond finally post their bond, but you cap them at 3. How do they choose which 3? Okay, so Maurice Jimerson, what do we got here? Man jailed 10 years without conviction. Is this Albany, Georgia, or Albany, New York? Albany, Georgia. Dang. Believed to be part of the nation's longest pretrial detention. I mean, I certainly hope that this is extremely exceptional, right? Like, can you imagine? There's like, hold on, wait, we've got one that's been here 11 years. Maurice Jimerson sat behind bars for more than a decade after being indicted for a 2013 shooting that killed Desmond Williams and William Davis Jr. So why is he here? Dang. So he pled out. They gave him time served. A negotiated plea deal of 30 years of probation. So they got you for life if they want to. So he takes a plea deal after sitting for 11 years. Because honestly, be honest in the chat, would you take this sounds crazy, right? If you're facing a charge, they offer you a plea deal with 30 years probation. It might not seem that enticing or that good of a plea deal. But if you've already been sitting for this long, I wonder what his before and after pictures looked. What did he look like when he went in versus when he came out 11 years later? 30 years of probation sounds like a death trap. Like, they're just going to come get you. But it sounds a whole lot better than going on for another year when you've already been stuck for 11 years in jail, in custody. And I don't know. So when you're being held without indictment, and I just have anecdotes here, but I hear a lot of people say that they'd rather be in the prison facility than a jail facility. It's different systems. You probably get to see more faces. You get to know people a little bit better. Jail, you probably have more in and out. But when you're held without an indictment, you're doing all of this time in a jail facility, not a prison facility. And just anecdotally, I've heard that there's a huge difference between that experience. So And yeah, that's true too. So JT says probation is jail on the outside. Yeah, and they can just scoop you up. Like, it's not hard to find someone violating probation. A lot of probation terms, you get a curfew, and if you make a mistake in updating, your job changes your schedule or something, you have to be on point. It's on you. And if you, like, I guess the probation officer probably has some discretion, but I don't know. Like, they have the power to make an issue. If you make a little mistake and don't update that your work schedule rotated and changed, you weren't home when you were supposed to be home. This is crazy, Drea. And one of 5 men charged with the shooting and killing of 2 men. So some of his co-defendants have pled not guilty throughout the years. Throughout the years is crazy. Jimerson remained behind bars. I feel like it might be Himerson or Yimerson. He remained behind bars for 11 years, never being convicted of anything. It wasn't until last year that Jimerson got his day in court, which ended in a mistrial. So he had a mistrial after over 10 years. Then they retry him, and then because of the retrial, he takes a plea. Is that what I'm getting from this? They told him after 10 years, we're still going to keep going. Sorry you had a mistrial. We're going to keep going. We're going into year 11 strong. They're like as insistent as LeBron James staying in the league to play with Bronny. So he had 45 days before his banishment to get his affairs in order. His probation will be revoked if he violates any terms of the deal. And I mean, guys, he pled guilty to aggravated assault and possession of the firearm. Maybe it's possible he killed this guy, but they charged 5 people with it. So without knowing the underlying facts of the case, what if his role in it, what if he's innocent? What if it was just, he had a firearm and happened to be in the wrong place at the wrong time? And he sat there without a trial for 10 years, ended up finally getting one. Then it was a mistrial and they tried to retry and he said, just plea me out. Like, this is crazy. And then shout out to Zion. I think I'm pronouncing that right. Zion 42. Monster streams today. Love it. Well, it's not my fault that Steele decided to file 3 filings before Love handed in her response late. And then Garrett says, are any Glanville long breaks really ex parte meetings? I mean, you never know. He just goes out there and starts talking to the state. And then thank you, Audra Swanson, for the $4.99 super chat, and Mia Joseph for becoming a member. And then, yeah, this is crazy. I know we thought, what do you guys want to pull up? The June 6th? Do you guys want to revisit June 6th? And hold on, this is going to be sad. You guys are you guys just having me pull up really sad cases where people sit without indictments? Oh, this was the one is this the one that Glanville feels guilty about? Because he feels like a murder suspect got away because of I know what you're talking about. Yeah, let's go over a quick AP article on this. Let's do a refresher. So thanks, Garrett, because this could help contextualize some of the stuff that we're seeing, maybe. So we'll just read this AP article to get a top-level summary, but this is all the way back in 2016. So Georgia's highest court on Monday declined to reconsider its ruling that says a judge can't set a new trial for a murder suspect, meaning the suspect will likely be allowed to go free without a jury ever weighing on guilt or innocence. Gary Otis ran up the stairs of a high-rise apartment building for seniors and wounded 71-year-old Emmanuel Surrey with a knife, and then he kicked down a door and fatally stabbed 75-year-old Mary Oliver on June 17, 2013. Prosecutors say police had to use a stun gun to subdue him, according to court records. Otis, who was 64 at the time, was a resident of the building but didn't know Oliver Surrey. He was arrested and jailed. When his murder trial began on April 7th, 2014, public defender Amanda Grantham asked the jury in her opening statement to find her client not guilty by reason of insanity, arguing that he had just snapped. Prosecutors objected, saying they hadn't been notified of an insanity defense and needed more time to prepare. Grantham said she wasn't required to give them advance notice because she didn't plan to call any experts. The judge overseeing the trial, this is where we get Glanville, Fulton County Superior Court judge, so he wasn't chief judge at this point in time. He said he believed prior notice was required by law. He didn't want to keep jurors long enough for the trial to be rescheduled, so he declared a mistrial. He said he'd put the case back on his trial calendar later. So he tried to rush something, get them out of there. No wonder he holds people for so long right now. So right in opening, right? I read that right. In her opening statements, she says, find my client not guilty, reason of insanity. Prosecution objects. Judge is confused, thinks that this disclosure may have been required by law, doesn't want to keep jurors waiting, so he says mistrial right in opening statements. And then what happens? Grantham objected to the mistrial, arguing that since a jury had been seated and the trial had begun, retrying Otis would amount to double jeopardy or her client improperly being tried twice for the same crime. The judge rejected that argument, and Grantham appealed to the state Supreme Court, which last month said the judge had erred. The High Court said no new trial could be set. The justices said that a 1995 ruling makes it clear that the defense doesn't need to provide notice of an insanity defense if no expert witnesses are to be called. That opinion came during the sentencing phase of a death penalty case, and Glanville interpreted it as only applying in that context. Because, guys, if there's a capital case with death penalty on the line, you have a guilt phase and you have a penalty phase. And it might seem like another little mini trial for the penalty phase because the defense, they have the right to try to argue that there's mitigating factors, that there's a reason that this person, maybe this is only something that happened in the past, but they could change, they could get healthier, they could get better, they could return back to society and reintegrate. So there's two distinct phases when you're dealing with death penalty cases. Are they guilty beyond a reasonable doubt? And then once we find that, well, capital punishment, should that be on the line? So, because remember, Georgia's a death penalty state. So Glanville interpreted it, this case law that related to a situation where it happened to happen in the penalty phase. He said, well, it only applies in the penalty phase. He took a very conservative reading of that case. The Supreme Court disagrees. So Fulton County District Attorney Paul Howard filed a motion asking the Supreme Court to reconsider its decision. Oliver's daughter tearfully pleaded with the justices to reconsider at a news conference organized by Howard and attended by Atlanta Mayor Kasim Reed. This is a sad day for the Oliver family. It is a sad day for justice, Howard said in an emailed statement on Monday. It is difficult to accept the release of this defendant who brutally stabbed an unarmed senior citizen simply because of a technical error committed by a judge who the court admits was seeking a fair trial. Otis will likely be released from prison in the next 2 weeks. So, if we think about that story, remember what I said earlier about overcorrecting? You know, same thing like when you're driving and maybe the road's slick and you feel your car going a little bit this way, and if you're not ready for it, if you panic, well, you're not supposed to panic when stuff like that happens. Some people will overcorrect. That's why you got to be careful when you see people weaving on the road. They're texting on their phone and they shouldn't be, and you see them kind of drifting into the lane. Well, when they realize it, there's a good chance that they might jerk the wheel and go too much this way, overcorrect and oversteer into the lane that you're driving in. And the same thing can happen in a philosophical way, in a theoretical manner. So maybe Glanville, with this case, he was so quick to make a decision, didn't want the jury to be hanging out for no reason, said, look, we got to keep this calendar on track. We're going to call a mistrial. We're going to get this back together because this happened right in opening statements. And now, fast forward to what we've seen with this YSL trial. No, we'll just wait. We're going to keep going. We're never, ever going to do a mistrial. I'm never, ever going to recuse. It's like he's got funnels on to just keep going forward. And maybe that doesn't make it okay, right? I'm not saying that that's an excuse or a justification. It's certainly not a legal basis if you should recuse yourself to not recuse yourself. But it kind of explains why he might be standing 10 toes down, might be kind of hard-headed about this. might be kind of a little bit disconnected when you see him making his arguments, when he makes a decision. It might seem disconnected from the case at hand and what's going on right in front of him, because his reasoning is tied back to this case from 2014 and 13. So great story. Great to revisit. I heard rumblings of it, but really to get that context here, which I didn't know, that this objection happened right in opening statements, and he agreed to the mistrial right away. I didn't know that context, and that's I get it. I don't think it's okay, but I get it. And no, I totally think that the PTSD, he did do time in the military, so probably from that, but I'm sure this has a profound impact on him to feel like he's the one that let this person get away. Yeah, and that's true. 10 toes doesn't matter if you're loud and wrong. You're still loud and wrong, but just standing 10 toes while you're loud and wrong. And then Ghost. Good to see you, Ghost. I know you've been in here, Ghost, but I'm a mess with the chat. Shout out to Ghost and Drea in the chat. They're holding it down. And yeah, okay, so that makes sense. That's also why he's all about case law. He might be scared to interpret case law. Like, you guys tell me your arguments and I'll rule on it later. I'll just deny it flat out without addressing the case law. And then we've got, do you guys want to do June 6th, whatever the timestamps were in that one motion? I mean, we do have the other motion. What was that? Let me find the second. It wasn't a motion. It was I don't think it was a motion. It was a motion. This one here. So an amended motion for the correct ruling, because he filed a motion to correct a ruling on improper objection by the state. And then they also updated it today. So if you guys want to check this out, it is 6 pages long. And I see, where's Kayla? I don't know. Kayla was busy getting calls. So she can hop back in. If she's in the chat and she wants a link, I'll totally drop one for her. But yeah, let's see. I don't really think that this one's going to be all that interesting. They're just going to argue about the way the state objects. So the correction, though, what they're correcting about this, they put this right in the footnote, that on or about Monday, June 10th, 2024, Mr. Williams filed a motion for correct ruling on improper objection by the state and served on this case and the parties. Mr. Williams hereby supplements this motion to add paragraph 11. All other information herein remains the same. So back in June, they took an issue with the prosecution making these countless objections based on 24.8.801C, self-serving statements of a party. And the problem is, not only were they making these objections, but that the court, in almost all instances, was sustaining the objections. But the objection nor the ruling was well-founded, argues Steele and Adams. So they're going to give some case law here. And then Mr. Williams has offered into evidence on many occasions supposed utterances of Mr. Williams, not self-serving statements, but in oftentimes lyrics, that this court has denied admission into evidence based upon the prosecution's potentially specious objections to self-serving statements. All of these issues are preserved for appeal in the ordinary course of litigation, but going forward, Mr. Williams asked this court to reconsider its understanding of a potential objection of self-serving statements based upon the case law and the warning and notation by the Honorable Supreme Court of Georgia. So this is where we go back to, look, there's no basis for the objections. It's unfounded that you're sustaining them. And then it's also, going against this case law here. We want to be able to get these lyrics in, but you're trying to bar them by hearsay. And have you guys seen any parts of the trial where Love wants to get in certain lyrics? She wants to ask what certain phrases mean. She's asking witnesses to give their theory of what song lyrics mean. Have you ever heard Jeffrey Williams talk about God and his faith? They ask all these questions about these things. So it's not just like Mr. Williams randomly wants his song lyrics to be played in the courtroom. His lyrics are being discussed and contextualized by the way Adrian Love asked questions about the lyrics to different witnesses. But Brian Steele says, well, let's just play the whole song then. Oh, we object. I sustain the objection. So Mr. Williams' lyrics or social media postings should not be barred by any hearsay objection because they become relevant based upon the prosecution's presentation of evidence under the rule of completeness. So just play the whole thing. And oftentimes are not admitted for the truth of the matter asserted, but for the effort on the listener or to put conversations and issues into context. But this court, for the most part, has prevented Mr. Williams from receiving a fair trial by sustaining possible and meritless objections by the prosecution. So they go back to cite a major change in 2013. And really, this was filed back in June, but we get one small update here that says the state argues that if a party is silent, then they adopt a statement by someone else. Same is not true. The same is not true because there must be a manifest adoption or belief that is true. So I thought this was an interesting ad because what is our big issue with June 10th? What is our big issue with June 10th? It wasn't that a meeting took place. It wasn't that the defense necessarily found out about the meeting. That might have indirectly been a problem. Why was Brian Steele held in contempt on June 10th? They had a problem with him being silent. They didn't want him to be silent. And then while he was silent, Judge Glanville kept inferring that he thinks he knows who told them about the ex parte meeting. So for the state to play on being silent, and then I forget the date, but I think it was like June 14th. Adrian Love filed a motion in limine June 14th, after the contempt happened, after Brian Steele was held in contempt, asking the judge to make a ruling that he would stop sustaining the defense's objections so much. It really seemed like we're going to file this just to, rubber band something back at the defense. And we did some videos on that. I think Thugger Daily posted the documents as well if you'd rather just read them instead of watch me talk about them. But we have this whole issue again of the state and the court. Well, we want you to talk. But if you talk, you might have to violate potentially privileged communications. But if you don't talk, we're going to hold you in contempt. And if you don't talk, we're going to take that as some type of, all right, you're adopting the statement that someone else is making because you're not objecting to it. But also, if you object, we want the judge to rule against your objections because you're objecting to our leading questions too much. And it's just like when you piece together all of the constraints and all of the asks that the state is asking of the defense counsel, largely Brian Steele, by the way. Brian Steele and Max Sharp seem to get the brunt of it. The state wants to put all these constraints on them. And even when there's an order in place that seems like it should go both ways, it doesn't matter when the state violates it. But if the judge wants to decide out of thin air, there's an order mid-court on June 10th, I'm ordering you to tell me who told you about this ex parte meeting. I'm going to hold you for the maximum allowable time in contempt. You've suddenly got to abide by that. So I think it's really interesting that we get this little addition, this paragraph, to this filing that was really made in June 10th. Or I have the date wrong. It was like June 7th. Yeah, it was June 10th. So they update this with this little paragraph today, refuting the idea, pushing back against the idea that the state has argued that if we don't say something, we're adopting the statement that's being said. If we don't object, we're adopting it. Like, just think about how crazy this is. So, the motion in Lemonade. And I think I had the date wrong. Yeah, so it was the same Monday this was filed. But it's just confusing because today's July 10th. So my brain was like, was it the 10th? But yeah. And I still think that this is, how do you guys feel about, if the defense wanted to, and maybe we'll see this in another response, but if the defense wants to defend themselves against accusations that Melnick shrugging shoulders over in their way and they're communicating with implicit gestures in the court, they could turn around and say, well, look, there's these other examples right on camera where we've got simultaneous ear tugging when you guys seem to be looking at each other. What's going on? They haven't really done that yet. And I think part of that is because they don't need to. I really don't think they need to make those arguments, because I think they have enough proper issues that they can raise without having to be petty by just saying, you guys held an ex parte meeting. You didn't disclose Brady evidence. You didn't disclose Giglio evidence. You tried to hold me in contempt of court for not telling you who told me about the meeting. You knew a witness was going to plead the fifth, and you put him on the stand anyway, and judge, you let that happen. And then you tried to backtrack it to make it seem like you didn't know. You insulted an attorney of record, John Melnick. You insulted me by calling me unprepared. And then when we called you out for being disparaged, you said both sides are doing it. Like, just think about it. I really don't think it's necessary. But they absolutely could, because you guys have pointed out several examples while watching the streams. Like, did they just signal to each other? So if you're going to accuse me of doing it, I can just send that right back. But I really don't think they need to. I really don't think so. And then let's see. So where are we, you guys? So Audra Swanson says, the DA said they wanted an ex parte on day 88, 5 hours and 40 into the day. So they did, and they wanted to meet that afternoon, that evening. And Glanville had already said, we're going to make sure Monday morning that he's willing to testify, or to make sure Copeland's willing to testify. But the problem with that is, like, I think that's what you're getting at too. They knew. They already knew that they were going to struggle, that this immunity offer, Copeland wasn't having it already. Copeland was he was given this immunity deal, and he gets back up and pleads the fifth. They're not confident that even after whatever happened in court on Friday, they're not confident that a weekend in jail is going to convince him to give them what they want from him on Monday morning. So really important to remember. And I think it's funny that Glanville was like, we're not going to meet today. We'll meet on Monday. And then still they end up not disclosing it. So if they didn't want to get caught, I guess you could make a fair argument they didn't do a good job of keeping their meeting a secret. They were absent for 2.5 hours. But it doesn't matter if it was apparent that they were having the meeting. They were still kept out of it. They were denied the transcript for like 2 weeks. It was close to 14 days, right? Yeah, because June 10th was a Monday and the transcripts came out on a Monday. So I really don't know how. I mean, that 9-page response from the state today, guys, is the best fight they could put up to defend themselves about this ex parte meeting. I don't think they did a great job, personally. So I appreciate you, Audra. And then Garrett says, speaking of silence, oh, we did that one, sorry. And then what happens now after all these motions? So Brooklyn T, some of these motions, this would be more of, I think Steele is filing this thing that we just looked at to kind of get some arguments on the record, right? To put some arguments out into the air, if you will. But at the same time, this could come into play if the trial resumes. It's basically saying, Judge, we want you to change your mind on the way you ruled on this. And in real time, contemporaneously, it would only matter if the trial starts back up. But some of these other motions, like yesterday's supplement, and then we see Judge Rachel Krause yesterday deny the order to recuse herself and also deny the order to disqualify the Superior Court of Fulton County judges from hearing Glanville's recusal. Where that puts us is Judge Krause, at least for right now, is going to be the one making that decision. And if she makes a decision that either party doesn't find favorable, they could take it up to the Supreme Court. Supreme Court has already signaled that they'd be happy to hear it after it's heard and decided at the Superior Court level. But if Judge Krause wants to follow the letter of the law, I can't imagine why she would oppose if either party requests a certificate of immediate review. So if she makes a ruling, say, for example, she decides we're not going to recuse Judge Glanville, and the defense goes, all right, well, will you grant a certificate of immediate review so we can take it right to the Supreme Court right now. Not wait until after this long trial is over. And she'll probably, I really think, I don't have a reason to say she'll say no to that. So even if she declines to recuse Judge Glanville, it seems like the smart move for her to make. The likely move would be, yeah, but you can take it on the fast track to the Supreme Court. And we know this, the Supreme Court's already like, we'll hear it, come back to us. So I think we've got, I don't know, I think in a week or so, we'll see something from Judge Krause. I don't know how long it'll take her to make her ruling, but she's been pretty prompt. What do you guys think? Do you think Rachel Krause has been prompt? Quick? And then, yeah, that's true too. So anything late Friday, there may not have been an attorney for, unless Melnick wanted to stick around. But he might have been out of that courtroom by that point anyway. Because when he was done talking, it was like, zoop. But yeah, so, and then Doug Weinstein withdrew the emergency petition for a writ of mandamus. Without prejudice, he can refile if he wants to. But it really isn't necessary right now because the case is currently being heard in the Superior Court of Fulton County. So he may refile if a certificate of immediate review is denied. He may file for another petition. Hear this quickly. We need you to order something to happen here at the court level. Whatever the case may be. But yeah. Ollie, I agree. You know, tomorrow, Rachel Krause right now is reading this 9-page response from Love and thinking, all right, how am I going to respond to this? So, and yeah, so for always and forever for life, I agree because Brian Steele, he fights appeals. His wife fights appeals. To me, they write like they're kind of writing for an appeal. Like they're putting the details in there the same way when you read an argument to an appeals court. You know, sometimes you got to tell them a little bit more because they don't know everything that's going on. They're not sitting in the courtroom every day. And they're not going to pull up a YouTube channel and watch the trial in full, especially not, can you imagine if appeals courts had to rewatch a trial and they're like, all right, we have to appeal this 100-day trial. We're just going to sit and watch Law and Crime for the next 6 months. Lots of popcorn, you guys. And then that girl, Mia, there was also that time when Woody said he was going to plead the fifth to Hilton after everyone was dismissed off the record, but caught on audio. When was that? I'm not downing you. Everything sometimes it just goes like this in my head. I'm just, especially with dates, you guys. It took me a while to get June 7th and June 10th right, and knowing that that was that time period. And yeah, green eggs and ham is ready for tomorrow. I need a break. I hope Rachel Krause takes till Friday. So, you guys, I have 2 videos done, ready to publish on the Sean Williams case in Tennessee. He has 2 different trials coming up. This is the guy with over allegedly 50 victims. There was police apparently being paid $2,000 a week, maybe a month, but I think it was a week, to not snitch on him. So even to the point where someone fell out of his 5-story window, a woman fell out of his window, they take her to the hospital and they don't properly test her for drugs in her system. And there's like 11 Jane Does that came forward that at this time period, while they were being ignored, you know, he possibly drugged them and the police didn't want to investigate it. And now they've come out in the last 2 months. One of the attorneys representing one of the Jane Does has the bank statements and they're seeing some of these $2,000 payments going back and forth. Well, in between this thing that's been brewing since 2018, he ends up getting arrested on an ammunition charge. And he's picked up in another state. It's North Carolina that picks him up because Tennessee has been ignoring him. The Johnson City Police Department's been ignoring him. But he gets picked up in North Carolina because he's parked in somewhere on campus property somewhere with a bunch of drugs in his car. And they also find hard drives taped together. And they're like, oh, they turn all this stuff over to the Johnson City Police Department because it was a federal charge out for him. He ends up getting transported back to Tennessee. And they sit on these devices that they found. It's not North Carolina Police Department's fault. Johnson City sits on these devices. The U.S. District Attorneys don't push for any warrants that would let them look for more. They sit on this until 2023. And then finally, they end up looking at these devices and seeing video footage of these same people that have been trying to say that he assaulted them or R-worded them. Video footage of them. So now the feds are looking at this, they're contacting the victims, and now Johnson City can't play dumb. They can't act like this is just unfounded and baseless. And they also found some footage. He had footage of children victims, guys, like toddlers. Like, it's not good. And the police were protecting this man. So he's finally in custody, only because he was picked up with drugs in his car by a district in another state. It has nothing to do with what Johnson City was doing. Finally got him in custody. He escapes on the way to a hearing where one of his attorneys wanted to withdraw. The back of the transport van is kicked out. There's no evidence that there was the proper mesh screening that should have been in there. And he was a high risk offender, you guys. So when you have a high risk transport, there's extra T's you gotta cross and extra I's you gotta dot. This guy, he's supposed to be belly chained. They find a paper clip on the floor in the back of the van. The people driving it don't know what happened, and that might be true. But he somehow is able, he showed up at a woman's house and she said he didn't have any restraints on. They find this paper clip in the bottom of the van. There's no mesh screen over the window. He kicks it out and he gets out and just right before he's supposed to be led into the courthouse, he gets out in the parking lot. And then he's like a fugitive for like over a year until someone identifies him in Florida and they pick him up, and now he's been in custody for a while, trying to get rid of lawyers. Lawyers are trying to withdraw. And finally, the judge presiding over the cases said no more. You either deal with this attorney or you go pro se. So his current attorney's trying to get out of it. He's got 2 trials, one in August for the serious, terrible stuff. And then he's got one on the 16th, so 6 days away from now. And that's for the escape. He could face 10 years in prison because he tried to escape from that van. And he also had another attempted escape that they merged in with this. It wasn't successful, but it was clear that he attempted it, I guess. So he really has 2 escape charges. But one was successful and he was out for like a year. So he finally has that one trial coming up. And I've got these 2 videos. It's a 6-part thing recapping this full story. I gave you the short of it. But I've got 6 about half-hour long videos. Some are a little bit longer, some are shorter. So it's probably going to be about 4 hours total, 3 hours total of binging if you want to catch up on the Sean Williams story. But I need a day off to get them finalized, start publishing them. His first trial is coming up. It'll definitely be up before his August trial. But guys, it's insane. If you guys don't believe, why would there be a cover-up? Let me pull up a picture of him so you can see who I'm talking about. Oh, come on. You know, they always want to give you pictures of people until it's a crazy white guy, and they don't want to give you a mugshot. There's crazier ones of him that I found. You guys aren't going to think this one's that awful. They get awful. Let me pull this up. But a quick search isn't yielding all the different photos of him. There's somewhere he looks real crazy. But this is who, if you guys see a thumbnail come up with this guy, the first video will have a big question mark over his face because they gave him a pseudonym while a U.S. District Attorney was saying, we need to search this guy. There's weird stuff going on. He has electronic devices and a stuffed child's doll in the safe where he keeps his money. And he had a note in his bedstand with the word grape without the G on top of it and like a dozen women's names listed under it. Can we expand the search warrant to be more than just looking for this possession of ammunition? They're like, nope. This is Sean Williams. His pseudonym was Robert Vell because they didn't want to give a face to the name. He used to be a well-known businessman in Johnson City, and it looks like his business associate was making payments of $2,000 at a time to a select group of police officers, so that way they wouldn't properly investigate or carry forward reports that they were receiving about his behavior, assaulting and R-wording women and children. And now, thanks to another police district who pulled him over and seized thumb drive. And then finally, 3 years later, someone decided, all right, we're finally going to look at it. Not North Carolina's fault again. They find video footage of what seems to be 50 different individuals, more than 50 different individuals that appear to be visibly unconscious in the footage with him doing the things that he's charged for. Have you heard this story? Besides from me, I've talked about it like 3 times. But besides from me, why haven't we heard about this? A case with 50 potential victims, where a city is being sued. A police department is being sued. It's more than one suit, by the way, you guys. Because the U.S. District Attorney, she's suing. Her name is Kat Dahl, D-A-H-L, Kateri Dahl. She's suing, not me. She's suing for wrongful termination because after the same time period, she was pushing to expand these search warrants. And then the police were letting the search warrants expire, and then you got to reapply for them over and over. So months were going by. She said, speed it up. Can we execute on this? Can we expand it? Oh, you don't want to expand it? Can we at least execute on this now? Execute on the search warrant? Well, when they finally do it, these dumb knucklehead police officers spend 45 minutes at his door. How often do police officers, if they really want someone, do they just stand outside knocking and asking nicely for someone to come outside for 45 minutes? The guy was inside the apartment, called 911 pretending, hey, my friend is in my apartment and told me someone's there looking for me. Do you know what's going on? Told the whole story. The 911 calls will be in the videos. But it's just like, why don't we hear about stuff like this? Why don't we hear about stuff like this? 50 different victims. And maybe it could all be false. Maybe, innocent until proven guilty or whatever. But if we're finding out now that there's supposed to be video footage with over 50 different people on it, if that video footage exists and that's not just a blatant lie, maybe it is. But if that exists, how do you explain away 50 different instances of something like that? Well, that footage just looks bad because we drank too much and she passed out and whatever. How do you explain that away 50 times with someone that's not even an adult in some instances? If the video footage exists, like, and it's just crazy. And you know what? That's true. Netflix documentary, both of these cases, maybe when it actually happens, maybe we will see something like that. But it's really been advocates. It's been the Jane Does. It's been the attorneys representing them. It's been the one U.S. District Attorney that lost their job. They said they fired her for performance, underperforming. But you know how that goes sometimes. And then just members of the community saying like, hey, Johnson City, can you like do something? Like, why are you not looking into this person? Can you give us some answers? But it's possible, you guys. Cover-ups can happen. It's not far-fetched or impossible. Why would multiple people know about something and not talk about it, not tell? This is an important case because it shows you that just because someone reports something, just because someone may have evidence, just because there may be 50 examples of evidence, doesn't mean it's easy to bring a case to justice. And it's the prosecution, it's the city that was standing in the way of this happening. You had a U.S. District Attorney that was trying to pursue this. She got fired for poor performance. And yeah, not the smile in the mugshot. So that's a big yes. So I don't know about the specific acts, but it's certainly alleged that they are being paid. And recently, there's filings with exhibits of bank statements, money being moved. So both through payments and through real estate transfers. So this is a big one, you guys. So we'll round this up here. Nick Starro, I want to connect with Nick Starro, you guys. He was in the chat earlier. Let me grab his channel because I think I'll be on his channel for it. Although I'll also post in the community post or whatever, so that way you guys can find out more. Maybe Friday. But it looks like we might talk about, let me see exactly what he wants to do. Yeah, a panel discussion. So I'm going to say yes. I'll be there on Friday. So we'll do that. We'll talk about more of this YSL stuff, these filings. And Nick Starro is great to rewatch some of the old clips with. He is so observant. and has watched this whole case attentively since pre-trial days. So, wait, and then is birthday stream right now? Do you guys want to do a redirect? Go over to a birthday stream? Oh, yes, it's Valhalla's. Okay. If you guys haven't met Valhalla Awaits, he's great. He helps in the LawTube space a lot. He's a great mod in a lot of other channels. You guys probably see him more than you realize. Let me do a redirect to that. Is it only on Nick's channel, Ghost? Like that's the source of whatever? So you guys can come in, shout out with a happy birthday when you get in there, even if you got something else to do. If you guys want to do that for me, say happy birthday when we all get in there. I'll hang out in there for a bit, of course. But say happy birthday to Valhalla Awaits. Nick Staro's in there as well. And then I'm slow. I don't remember how to do a redirect. So I wish I could share my screen and show you guys how I struggle stream. Let me see. Let's go into my live. Live now. Customization. Yeah, we got a redirect. Let's go to the birthday party. And are you sure? Hold on, wait. I see Valhalla has the stream too. And then let me set up. I'll redirect to Valhalla. And then we also have. You guys said Dear Woke Christian is doing YSL with. Was that with Infamous Sylvia? Okay, so drop a link. If you guys want to continue YSL Convo, the link I just dropped is going there. If you want to come say hi to Valhalla Awaits, Nick Staro, and the birthday panel, I think MLS Law is in there too. I think Brandy with the 13th Juror. Is that her podcast name? Brandy Churchwell is in there right now. So that'll be a great, great panel as well. That will automatically redirect you. You'll carry over with us. So whatever you guys want to do, see you wherever next time. Thanks for tuning in. You guys all have a good one. Thanks so much, Ghost and Drea, for modding as well.